one, the 21st Lancers, a much longer and a blacker one, the Egyptian squadrons, a mottled one, the Camel Corps and Horse Artillery. From this distance, a clearer view was possible, and we distinguished many horsemen riding about the flanks and front of the broad, dark line which crowned the rest of the slope. A few of these rode endlessly towards the squadrons to look at them. They were not apparently acquainted with the long range of the Lee Medford carbine. Egyptian squadron. Several troops were dismounted, and at 800 yards, fire was made on them.
Working? Oh, that's pretty noisy. If you hold it down.
Hear you.
Hello. Hi. Okay, sorry. Can you hear me? Hold on. I don't know what I did. Okay, you can hear me now?
Can you hear me? Yes. I think I'm.
Okay, it's about 9 o'clock. I'm going to start calling the dockets. I noticed that we have a lot of attorneys here on Yell. Was it today that they had asked if they could just move their hearings until 1 o'clock?
On San Miguel, 1 o'clock tomorrow.
Okay. I mean, you can see we have 56 participants. I don't expect that I'm going to get to you much before 1 o'clock today. Do we want to just?
That's fine with San Miguel. I don't know about Mary.
That's absolutely fine, Your Honor.
Okay, so I will excuse everyone here on San Miguel until 1 p.m.
Thank you.
Thank you.
Thank you, Your Honor.
Right. I have not gotten a list of who's in custody from the criminal docket for Atascosa County State. Michael Tejerina. All right, Mr. Orta. All right. No show. Jose Martinez.
He is present here at the probation department, Your Honor.
All right, have we heard from Mr. Shaughnessy?
I have not, sir.
State versus Jacob Zamora.
Council's present. This is a hearing for to compel fingerprints.
Okay, is Mr. Zamora here?
Let's see.
Right, I'll mark him no show. Bernadette Cuellar. Mr. Perez. No show. Rafael Tejerina.
Michael here, Your Honor, with counsel for Ms. Pratt.
Okay, is he with you or?
Yes, I am here.
He's not in my presence, but he's online.
All right, thank you. Justin Peacock. Justin Peacock.
Your Honor, on that case, I'm not ready.
I'm sorry?
I'm here on that case. My client, this is supposed to be a open plea on the NPR, but my witness and some medical records are not available today. Is there any way we can recall this for Wednesday? I just filed the plea papers right now with the court, but he has signed off. We're going to enter a plea of truth, but go open to the court.
Okay, but your client's not here?
He's in jail.
Oh, he's in custody. Okay. All right. Let me ask the sheriff's department or someone. I need to get a list in advance of who's in custody. Yes, that's fine. So make that for 11/11.
We're off
Court
on that
Wednesday?
day. It's 11/12, sir.
Okay, 11/12. I was about to say that's better today.
I'll send it to you on pursuant the way you request.
Thank you. Katha Green.
Yes, sir, I'm here.
All right, and your attorney, Mr. Otero?
I don't see him on the,
He should be there. All right, please try and get in touch with him. Frank Sandoz? Mr. Flores, is he here? He's coming in right now. Ernesto Velasquez? Ernesto Velasquez? All right, are you Ernesto Velasquez?
Yes, sir. Yes, sir.
Okay, I'm going to rename you and we're waiting for your attorney. And it sounds, sir, like you have the sound going on more than one electrical device. Please make sure you only have one on or we get that kind of echo.
Yes.
Yes.
And I can tell you've got more than one going because you're muted, but I still heard you say yes. So, all right, Mr. Flores, is your client, Mr. Sandoz, present?
The refrigerator's right there.
Judge, I spoke with his brother on Friday and gave him.
Sandoz is here.
Yeah, I had given him the information. I do expect him here, Judge.
Okay, who just said Sandoz is here?
I'm present. I'm present, Your Honor.
Okay, where are you present?
Pardon me?
Where?
Oh, I'm in Alamo Heights in San Antonio.
And are you with Ernesto Velasquez?
What?
You gotta use one or the other.
Okay. There are two phones going. I'm about to shut one of them off.
You need to give off of there.
All right. Okay, I'm going to put this phone back in the waiting room. Andrew Serta.
Morning, Your Honor. He is present with counsel.
Jesse Fernandez.
Present with counsel as well, Your Honor.
Present.
Delmiro Garcia.
He's present here at the probation department, Your Honor.
And counsel's present, Your Honor.
Kevin Pavelic.
He's present with counsel, Your Honor. We'll confer.
Jasmine Thurman.
She's a no-show for now, Your Honor, I believe, but I do expect her on, Your Honor, so we'll update the court shortly, I'm sure.
Morgan Booth.
Counsel's present, Your Honor. I don't see her. I spoke to her this morning. I will get her on.
I'm here.
Oh, she's present. I just found her.
Jack Cedillo.
He is present with counsel this morning, Your Honor.
Lupita Fernandez. We heard from Mr. Briggs.
No, sir.
Monica Garza.
I am here for her, Your Honor. I had sent her an email. There's no response. If you can recall that for later on.
I'll mark her no-show with Ms. Fernandez.
Sir, I misspoke. Mr. Briggs notified us this morning that he's in Carnes first.
All right, thank you. Gabriel Hilburn. No show. Abby Oliva. This is coming in. All right, Mr. Perez on Gabriel Hilburn. Abby Oliva.
Yes, good morning, sir. Gabriel Hilburn's logging on right now. He's having a little bit of computer problems. He's been tendered an offer. He's rejected that offer, and we'd like to reset for a breach. For Abby Oliva, I've not.
Okay, wait. All right. There's a phone that says Ernesto Velasquez. I have put that number in the waiting room once because they keep turning their speaker on or their microphone on, and another phone going or electronic device, and they're causing interference.
Your Honor, hi, this is the defendant's daughter. I'm only showing one on the Zoom call. Everything's muted on our end, so I'm not sure where that's coming on the as far as the name.
Okay. Well, there's another one. So I just asked a phone to unmute. Who is that?
It's showing you.
Okay, ma'am, I've got you. There's two Ernesto Velasquez's on here. I just asked the other one to unmute. All right, back in the waiting room. Okay, Abby Oliva.
Judge, I've not heard from her since before the pandemic. She did sign a COVID form. She did put two numbers on there, neither one of those works.
Okay, no shot. Alexander Palma.
Your Honor, counsel's present. know that he was in custody on a blue warrant. I don't know if he's still in custody. I think his discharge date was coming up. I can check on him.
Okay. We'll check on that. Carlos Signs.
He's in custody. There's been an offer tendered and rejected, and we'd like to set that for trial as soon as we can.
Billy Truelove.
Mr. Truelove in custody, Your Honor. Counsel's present.
Charlene Hatfield.
Counsel's present. Let me check on her. I think she had logged in under iPhone, but I don't know if that's her, Judge. Let me check.
Is Darlene Hatfield online?
I'm here.
All right, ma'am, I'll change your name on the,
Darlene Hatfield.
okay, I have you down. Marker present. Brandon Kubish.
She
I'm
should
here.
be, she should be on.
I'm here, Your Honor.
There she is. We have conferred with the state, Your Honor. We are unable to reach an agreement with them. At this time, we are asking that we be put on the jury trial list. We may end up going forward to the court on punishment, but for now, if we could be put on the jury trial list.
Okay, you need to get those dates from Miss Poppy. She is online. And Miss Poppy, I tried to make you, I got kicked off for a moment and I tried to make you the host right now.
I don't think I am, sir, because I don't see breakout room capability.
Okay.
And I'm going to post the date that folks can use if they want to remain on.
Thank you.
for trial.
I just clicked make host again.
So Judge, do we just stand by and wait for further instructions or what do we do?
Okay, you need to get the dates from Miss Poppy, and then for all the attorneys, we're not sending out notices, okay?
Okay.
Get the carbonless copy we used to get because we're not in here in person. But when you get the date, you need to send a chat message that has the cause number, and don't write cause number in front, just cause number, name, date, or dates if you have like multiple dates. And send that to me in chat. That is your record of when you're supposed to be back in court. I have my chat automatically saved, so we get a copy of that every day. If you will set your Zoom account up so that it automatically saves chat, you'll know when you've agreed to be back here. And after you've done that and you've seen that it's gone through on all your cases, you're released. You don't need to come back and ask. State versus Justin Schaefer.
Judge, my name is Lee Cox. I'm here. Mr. Schaefer was in Collin County. Apparently now he's been transferred back to the holiday unit within the past week. I have not been able to reach him since he's been back in the holiday unit, but that's where he is right now.
All right. Thank you. Is that all you have?
That's all I have, Judge.
Okay. It just, as soon as you get a date to monitor, we're having some issues with TDC where they're no longer cooperating with Zoom hearings. They're only putting them on by telephone.
Correct.
So as soon as you get a date to monitor this and see where we're going on for Zoom hearings, send that to me, cause number, name, date, in chat, and you're released. Brandon.
Thank you.
Brandon Harding.
Your Honor, I'm here on that. It's going to be a plea by Zoom. They're not going to be ready till 11:45.
Okay, and he's in custody?
In Williamson County. So I've been in contact with Ms. Poppy. He already sent.
All right, so 11:45. We'll take it up then. Michael Castillo.
Yes, Judge. I'm here on Michael Castillo. He is supposed to be at probation.
Here, Your Honor.
All right, thank you. I'll mark you confirmed. Nathan Perez.
Yes, sir, I'm here.
He is present, counsel, Your Honor.
Mark you confirmed. Travis Spain.
Yes, sir, I'm here.
Present with counsel, Your Honor.
Mark you conferring. Okay, and Ms. Poppy, if you would make me the co-host, I'd appreciate it. Criminal additions, Cristobal Estrada.
That's myself, Your Honor. I believe that she is still in custody, and this is just a competency, I think an agreed competency.
Monitor, you're asking for a competency evaluation?
Well, I think that she's been evaluated, and I think that there's agreement that she is not competent, and so I think the question is who produces the order for sending her to a facility to regain her competency.
And do you need to have a hearing on that?
Well, I just need somebody to tell me who needs to do it, if it's me or if it's the state or if the.
All right, I'll let you confer with the state on that.
All right, thank you, Your Honor.
Okay, anybody else told to be here today on a criminal case, your case was not called?
Judge, did you call?
This is Jasmine.
One at a time.
Judge, was Jimmy Underwood called? You'd be an add-on for a bond hearing.
Hey, that's a nice, that's not a criminal case, it's a writ.
Okay, okay.
Okay, Jasmine Underwood, no, Jasmine what?
This is Jasmine Thurman. I did the Zoom video, but I guess it wouldn't let y'all hear me, so I called in this instead.
Okay, I will mark you present.
Judge Wilson, Mr. Orta is on.
Okay, and if you could make me the co-host, I'd appreciate it.
Yes, sir, I just did that.
All right, Mr. Orta on Michael Tijerina.
Yes, I had filed a motion to set bond. He's on a deferred. I had conferred, but I guess he still needs, I need to send the prosecutor the copy of the motion.
Okay, so is he in custody then?
Yes,
All right, because I had him down as no-show, but that would be why he didn't show up, I suppose.
Say it again.
Well, I had him down as a no-show, but I didn't.
No, he's in custody. Sorry.
Oh. Okay, I'll mark you conferring. If y'all need breakout rooms, please get with Ms. Poppy. She is the host.
Thank you, Judge.
Anybody else told to be here today on a criminal case your name wasn't called?
Your Honor, Alexander Palma is on right now. His phone number ends in 2062. I don't see him in the gallery, but he says he's on and that he can hear. Oh, I'm sorry. His number ends in 3947. Yes, and he's on right now, Judge. He's muted.
All right, I'll mark him conferring. So I suppose he doesn't have a blue warrant.
No, Your Honor, no.
Okay, I'll mark you conferring. Anyone?
All right, same for Gabriel Hilburn, Your Honor. He's logged on as well.
Okay, right. Your Honor, Frank Sanders is present.
Okay.
Just confirming.
What is, okay. Sir, how many electronic devices do you have where you are hooked up to this meeting?
The computer and the phone.
Okay, you shut one of them off. The next time I hear an echo from you, I'm going to remove you from this meeting and you can just show up in person, okay? It's at least the fourth time I've asked that. I don't try to get sharp with people, but you need to pay attention. All right, Mr. Pavelik?
Sir.
Remove your hat. You're in court. Okay, is that it on the criminal cases? Okay, then I'll release everyone to confer. I'm sorry, who spoke up?
Yes, I'm here on behalf of Ms. Cata Green. I was in another Zoom meeting, but I'm just announcing that I'm back here and I'll confer with the state.
All right, Mr. Otero, I'll mark you conferring.
Thank you, Judge. Okay, on the civil side. In the interest of Willow Grace Marler, a child.
Your Honor, oops. We reset that to Thursday. Mr. Gear had some issues with today's setting. So we have a Rule 11. I've already sent it to Ms. Riley on Friday.
Okay, thank you. I reset the agreement until 1 p.m. In re Yvonne McAllister, expunction.
Present with counsel, Your Honor.
Okay. And has there been any response filed in that case?
I don't believe so, Your Honor. Last week I was updated that we were only waiting on one notice to be sent back. However, I have not received an update after that.
Okay, I will, number one. In the matter of the marriage of Stephanie Benavides and Gabriel Valdez.
Yes, Your Honor, that's also my case. We served Mr. Valdez by alternative service. I have verbal confirmation that that took place, but I have not received the written document from the process server as of this morning. I was going to ask the court if he was not present to just let us, if you're willing to do it, to let us put on evidence, but to not enter the order unless and until we can prove the service.
And Your Honor, this is Corey Calvano for the Office of the Attorney General. Your Honor, the Attorney General has not been served with any pleadings in this matter. I'm not 100% sure if we need to be because I haven't been served with any or we haven't. So maybe if I can speak with counsel.
Okay, Ms. Poppy is the host. She's in charge of the breakout rooms. And I'll mark you number 2 right now, Ms. Vickers, and let you confirm.
All right, thank you, Your Honor.
Okay, habeas corpus, David Arocha.
Your Honor, I've spoken to Mr. Bettis on this case. I can confer with him again. This case was indicted on Friday. We can confer.
Since it's indicted, Judge, I'll drop that. I'll send you an order just to deny that as moot, and I'll confer with Mr. Lim.
All right, thank you. In the interest of the Valdez children, 99-645. Daniel Garcia. Now this says it's an AG case.
Yeah, I thought that was the same case as the one with Miss Vickers, Your Honor. I don't believe that the AG has a setting in this court on that matter.
All right, is that the same family?
It seems to be to me, Your Honor.
So they're both Valdez's. It looks like they would have been out by now.
Are you talking about my case or a different case? I'm sorry.
That's the question. Okay, there's 99-12-645. Old. It looks like all of those kids ought to be 18 unless they're handicapped or something. Child support shouldn't be payable, but that 90 cases on the docket on Valdez. And the AG's office thinks it's the same as your case.
I believe those are the same parents, Your Honor. We can, maybe he and I can confer about that.
Okay.
We go to confer.
Sounds good. All right, and
Ms.
Mr.
Victor, who do you need to be in a breakout room with?
Mr. Calvano and I need to be in a breakout room together.
Okay, I'll put you there.
Okay, thank you.
Okay, Mr. Ernst. On Jimmy Underwood.
Yes, Your Honor, that's a writ. I'd ask to be put in a breakout room with Mr. Underwood first.
Okay. Is he at the Atascosa County Jail or what?
Yes, Your Honor, he is.
Okay, I'll ask you to get with Ms. Poppy about that.
Okay, perfect.
Okay, anybody else told to be here today? Your case was not called.
Yes, sir. This is Stephanie Benavides. I think that was my last case with Ms. Vickers, the client.
Okay. All right. Yes, ma'am, just your case was called. She's conferring with the Attorney General's office. She'll be back shortly. All right, Mr. Guevara, give me a moment to sign on and look at the clerk's records and see if anything was filed in that case.
Yes, sir.
Your Honor, I see Mr. Shaughnessy is in. I would believe that he need a breakout room with his client at probation.
Okay. Ms. Poppy's doing the breakout rooms. I've made her the host, and only one person can do breakout rooms.
I am working breakout rooms. I'm trying to do like 4 right now, so one moment, please.
Will do.
Can the jail put Mr. Underwood in front of the Zoom meeting? So I can put him in a breakout room with Paul Ernst?
Yes, ma'am. We'll get him right now.
Thank you. Mr. Thon, can we put Mr. Martinez in front of a computer at probation?
He's here.
Okay, is it Atascosa County CSCD?
Yes, ma'am.
Okay, I'm going to put him in a breakout room with Mr. Shaughnessy.
Okay, thank you.
Excuse me, Your Honor. Do we have other dates that are not jury trial dates? One of my client is filling out PTD paperwork.
I'll post those to everyone.
Thank
Not
you.
for
Ms. Poppy.
pretrial diversion.
Yes, Judge.
We don't give them a date typically anymore.
Oh, okay. Just like a status follow-up, but okay.
We used to do that, but right now it kind of just goes into limbo.
Okay.
All right, Mr. Guevara, do you have your proposed order?
I do, Your Honor. It was filed with the county, Your Honor.
Okay, I don't have it with me in front of me. If you will post that to me in chat, I will sign it.
Yes, Your Honor. You wanted me to send it to you privately?
No, if you'll just go to chat and send it to me, just click on file next to my name on chat, and you can send it to me directly in chat.
Yes, Your Honor. Thank you. We'll do that.
All right, and we have a plea on Brandon Harding.
Yes, Your Honor. He's in the Williamson County Jail.
Okay.
They informed me that they won't be able to do it until 11:45.
Okay, that's fine.
Okay.
Okay, Your Honor, I just sent it. If you could just please confirm you received it, Your Honor.
I haven't.
All right. May I be excused, Your Honor?
Yes.
Thank you.
Actually, hold on. About twice a week, I can't open documents and I have to reboot my computer. Okay. I can open this one. You're excused.
Thank you, Your Honor. You have a great day.
And Judge Wilson, just to let you know, we're going to need hearings on Nathan Perez, Travis Spain. That would be one hearing for both cases and also for Michael Castillo.
Okay, and how long?
Michael Castillo will be very quick. I don't Nathan Perez and Travis Spain together probably be 30 minutes, if that.
Okay. Okay, I'm sorry. There's a whole bunch of documents attached to this expunction order that don't need to be there. Let me take them out. All right, are those folks in custody?
No, Michael Castillo is at probation, and then the other two are appearing by Zoom.
Okay. All right. So are both sides ready to proceed on either of them?
Mr. Zamora is representing both Nathan Perez and Travis Spain.
And Your Honor, we're ready. I mean, the state's announcing 30 minutes. I mean, from what they're requesting in their motion, I thought this was just going to be the court advising them and asking if they wish to waive a conflict of interest. I mean, I didn't think that was going to take 30 minutes.
I put an upper limit on 30 minutes. I had no idea what your position on the matter was going to be.
Yeah, Your Honor, this is just real quick for the court's information. I'm representing two co-defendants. The state is asking them to waive a conflict of interest. I mean, I can get an affidavit on file for the court to approve. For my records, I had them sign already a waiver, but it's not an affidavit form. But I mean, I can get one in affidavit form and file it of record.
Okay, and what live testimony do you expect you need, Mr. Thornton?
I'm not going to have any live testimony.
Okay.
So my understanding, based on the case law of how this works, is once the court becomes aware that there's a potential conflict of interest, the court actually is responsible for conducting an inquiry into making sure that both defendants knowingly are waiving any conflicts, making sure the court is satisfied that that waiver is appropriate. And if not, then the court can either agree, the court can either agree to the waiver or not allow counsel to continue. And so that's what we're asking the court to do, is conduct that inquiry. And because sometimes, depending on the facts, it's appropriate for the state to be involved in that, and sometimes it's not. But we're bringing that to the court's attention. I'd like an opportunity to explain that to the court, and then let the court conduct the inquiry it feels is appropriate.
Okay. All right. Give me just a moment and we'll start that.
Brad, is there any way you could hop into that breakout room number 6 and get Mr. Otero out of that room? He wanted to speak with you. Just let him know that you're about to have a hearing.
Sure.
I can't move him back without forcing everyone to close out.
All right, and will someone send me a copy of the indictments in the cases that Mr. Zamora has?
Okay, I'm back.
Brad, was he needing to speak with you, or could he speak with Kenny or Adriana?
He was needing to speak to me.
Okay.
Yeah, I think he's going to approach you with a request for a reset.
Okay, thank you.
Your Honor, I don't believe Cuellar or Oliva have showed up, and that's all I have left. Maybe excused.
Sure.
That civil order, I'll e-file it for your signature, the order denying. Okay?
Thank you.
Thanks.
You're all right. Sorry.
Ms. Benavides, I just sent you the expunction order.
And I'm trying to send you the other indictment as well.
Thank you.
You're all right. I've been unable to contact my client. If he shows, I can be available, but may I be excused?
Yes, sir.
Thank you.
Okay. Are we ready to proceed in State versus Travis Lee Spain and Nathan Taylor Perez?
Yes, Your Honor, state's ready.
Defendant's ready, Your Honor.
I have received copies of the indictments. They appear to be in the alleged action identical.
Correct.
Okay. All right. Go ahead, Mr. Thornton.
And I'm emailing you copies of the motions right now, just
Okay, thank you.
in front of you. But so, Your Honor, this case, as you can see by the indictments, is a case that's alleged deadly conduct through discharge of a firearm. And the basic facts represent that both defendants were discharging a firearm in the direction of a home, is what we've alleged in the indictment. And the result of that was that somebody was shot, of course, which only one of them is capable of doing. And so, although we are alleging both of them were discharging a firearm. So in this case, their interests lie against each other in that the potential punishment for one is greater than the other, and they both have something to gain by showing that the other one was the one who caused the injury versus themselves. There's also a potential that the state will want to engage in plea negotiations with one at the detriment of the other. And so what the courts have said is that whenever there's an actual conflict of interest, it can be so great to where it can't be waived by the parties. And but at a minimum, it has to knowingly be inquired into by the court, and a waiver has to be put on record that both are aware of the potential downfalls of that in their case and are knowingly and intelligently agreeing to waive that. And that's what we're asking the court to make a determination as to whether or not that conflict of interest is something that should not be able to be waived, and if it can be waived, that they're knowingly and intelligently doing so.
Okay, Mr. Zamora?
Your Honor, if it pleases the court, I'm sorry?
You want to have your client sworn, or?
I'd rather them not testify, Your Honor. That's
okay. That's fine. Go ahead.
If it pleases the court, Your Honor, I've been deprived for 30 days almost of not being able to see the discovery in this case in direct violation of 3914. But from what I understand, and there's no exception under 3914 to be withholding discovery in this kind of situation. But from what I understand is that this is a situation that occurred in Bigfoot, Texas, on some rural property. A neighbor is alleging to have been struck by either a bullet fragment or a bullet. I'm not sure. But what I am sure of is that my clients, number one, if they were shooting, they weren't shooting in the direction of this property. And number two, if this case does proceed to trial, there's going to be witnesses that state that there was other people in the vicinity that were firing firearms. Law enforcement heard this. Other family members that were there heard gunshots in the area. So my clients don't have a differing defense. I mean, they don't have inconsistent defenses. Their common defense is that this bullet or fragment or whatever it is didn't come from their property.
Okay. All right, and Mr. Thornton, what's the purpose of withholding discovery?
Well, Your Honor, if the court, I just wanted to give the court an opportunity to determine whether or not Mr. Zamora can continue representing them both. Because if the court decides that he cannot represent both, then providing discovery may not be appropriate in a given case if he's completely taken off of the case or whatever the result that the court determines. The purpose is to withhold until the court decides what's appropriate, and I will continue with what's appropriate at that point. I have no problem giving discovery. There's no problem at all. It's just in terms of till the court makes a ruling on whether or not Mrs. Zamora can continue representation based off of the waiver, then we're more than happy to provide that immediately.
All right, I'm going to order you to provide the discovery, and Mr. Zamora needs to review it with himself and review it with his clients, because I don't know that until they know what the state's evidence is that they can make an intelligent decision about whether to waive their rights or not. So let's set this. Well, I order you to turn the discovery over, and Mr. Zamora can confer with his clients individually or together. And if they still both want him to represent them, then we can finish up this later in the morning.
Oh, you mean today? Or you don't want to reset it for another day?
I will reset it if Mr. Zamora and his clients need more time. But again, I don't know what the discovery says. If you've got signed sworn statements that say, yeah, it was one of them, it was the big elephant rifle he had that we know what it was.
Sure.
If it's just, a bullet came through the wall and we think it came from whatever property these two are on, something else. So I don't know that anybody can make an intelligent decision until they see the discovery. So I ask you to turn that over.
Your Honor, if I could get a reset date, because I'm working from home today, so I don't have a printer, and I'd like to be able to kind of print this stuff out and digest.
All right, that's fine. Just ask Ms. Poppy for that and send it to me in chat. You're excused after you do that for both cases.
Thank you.
All right, and Mr. Otero? He's still on?
Yes, Judge.
All right, I'm not trying to be an ass, but I'm asking everybody use the same format of cause number, name, and date. The reason I'm asking that is whenever this chat gets printed or saved, it's saved as a text file. And if we have cause number, name, date, then we can just go straight down the list and know and read and know exactly what's been reset for when. If people start writing a little homily and mixing everything up, then we have to stop and individually read every single line and search out the cause number and the name and the dates in there. So I'm going to ask you to just send that back to me in chat with cause number, name of your client, and date. And after you do that, you're excused.
Thank you, Judge. I'm sorry about that.
All right. It's the first time you've heard that.
Yes.
Okay. What else do we have that's ready to go?
Your Honor, Mr. Calvano and I have agreed that he is he's not necessary because we're proceeding on a divorce and a change in visitation. We've agreed to consolidate the case. I'll do a motion. I'll do an order consolidating that he'll sign. And I just received the citation, the alternative service citation, which we have submitted for e-file. And we'd like to proceed with temporary orders. It should only take 5 minutes or so.
Okay, and let me ask, were there additional children added to that 1999 case? It seems to me that
yes, apparently there are there are 4 children. 2 of them have aged out, and there are 2 children left, the 2 youngest, Gabriel and Cornelio. And
okay, I just wanted to make sure.
Yeah, that those children are no longer part of the case.
Okay, all right. Ms. Benavides?
Yes.
Would you raise your right hand? You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead, ma'am.
All right, Ms. Benavides, would you state your full name, please?
Stephanie Benavides.
And Miss Benavides, are you the mother of Gabriel Alexander Valdez II and Cornelio Alexander Valdez?
Yes, ma'am.
Okay, now you heard me state to the court that the older two children have aged out. Is that right?
Correct.
And these two children are both still under 18, correct?
Correct.
Now you have filed a divorce in this case from Gabriel Alexander Valdez. Is that right?
Yes, ma'am.
All right, because you and he actually got married after the first Attorney General order regarding your children. Is that correct?
Correct.
All right. Now, you are asking for temporary orders because you would like to be appointed the temporary sole managing conservator and have Mr. Valdez appointed temporary possessory conservator in this case. Is that correct?
I wanted to speak with you about that because I want to actually change it.
Okay, what are you asking the court to do today?
I want a divorce, but I want to fight for full custody.
Okay, well, that's basically what we're talking about. You and I discussed this before. So if you're temporary sole managing conservator and he's temporary possessory conservator, that gives you more rights regarding the children. And we're going to talk about you're asking for a limited visitation. Is that right?
Yes,
under these temporary orders. All right.
Yes.
Mr. Valdez went to rehab about 8 years ago, and it is your testimony that he has a serious drug problem. Is that right?
Correct. I understand that he just recently went to jail. I don't even know if he's incarcerated right now because he called one of my children to get him out of jail, which of course they're underage. And I just feel like he's just doing a lot of inappropriate things concerning the children.
Okay. Now, when he went to rehab some years ago, he didn't do the halfway house or the outpatient, and he left without completing the program. Is that right?
Correct.
And it's your testimony that at that time he was doing cocaine, heroin, meth, and drinking alcohol, correct?
Correct.
And then he also got a DWI, as far as you know, in 2013.
Yes, ma'am.
All right. And in 2019, you said that he made some kind of a false police report about his own mother's broken window. Was that your understanding?
Yes, ma'am.
All right. Now, where does Mr. Valdez live, as far as you know?
On 1307 East Power Avenue, Victoria, Texas.
Okay. And that is where we attempted to serve him. Is that right?
Yes, ma'am.
All right. And you are asking that he have some kind of limited visitation and that be supervised by his brother, who also lives in Victoria, about 10 minutes away from the address that we have. Is that right?
Correct.
All right. And are you asking for visitation to be once a month on a Saturday, supervised by him? Supervised by Mr. Valdez? Pete Valdez, his brother.
Yes.
All right. You're not asking for any change right now in the child support, is my understanding. Is that right?
Correct.
All right, Your Honor, that's what we have to put on for temporary orders.
Okay, I'll find I have jurisdiction to hear this case. I'm sorry, Mr. Calvano?
Nothing, Your Honor.
I'll find I have jurisdiction to hear this case. I'll find that the presumption that the parents should both have significant access to the children has been rebutted, and I will grant the relief prayed for on temporary orders.
All right, Your Honor, thank you. We'll prepare an order. May we be excused?
Yes.
Okay, Ms. Benavides, that means you can leave the meeting. We're finished.
Thank you. Thank you.
Okay, and on the Harding case, let the state know that I'm going to need the indictment in the state's exhibit.
On which case, Your Honor?
Brandon Harding,
Brandon Harding? Okay.
Williamson County. It says Wilson on the docket, but I think it's Williamson County.
That's correct, sir.
So the state's exhibit was not included in the plea packet?
Not what got back to me. I know it had to go to Williamson County, so I don't know what they did.
Okay, well, I'll send that over, Judge.
Judge, can I just ask a quick question to everyone?
Go ahead.
Does anyone need a breakout room, which I may have missed in the chat? I think I have everyone situated, but please let me know.
Hi, Miss Poppy.
I have-
Breakout room, please, with Bradley if he's available.
And who's this right now? Miss Corolla?
Brad?
Okay. Who else?
Horta and Michael Tijerina.
Who do you need a breakout room with Mr. Tirahina?
No, with the prosecutor, Thornton.
Okay. When he's available, I'll put you in second. Anyone else? Brad, are you available right now?
Me, Jennifer, if I may, I think either Mr. Thornton or actually whoever's available, or Adriana.
Okay. And Mr. Thornton, are you available right now?
I am.
Okay. Thank you.
I go into Fantastic Sam's. You can sign up for a particular one or first available.
Exactly.
Before I go in here, though, I definitely need a breakout room with Michael Baird at some point. So I will be right back.
Your Honor, Michael Zamora, I posted the reset dates for Travis Spain and Nathan Perez. Is that all that's required?
Yes, sir. You're released. Thank you.
Okay.
Your Honor, I was going to ask the same for my clients if Ms. Booth and I could be excused, as well as Mr. Edelmiro Garcia, which is in probation. We
Right.
posted the dates in the chat.
Yes, you're excused.
Thank you, Judge.
And Your Honor, similar announcement. I messaged you, Jimmy Underwood. We have an agreement, and that's going to be dropped.
Okay. And what I would ask is if you would just send me some kind of order that would, whether it's a dismissal or an agreed order setting a bond or whatever you're, I'm not even sure what you're asking for on Jimmy Underwood.
Yeah.
Your Honor, it's going to be an agreed order to set bond at a lower amount. The one thing I would ask that Mr. Ernst do is I have a copy of our standard conditions of bond that I would ask to be attached to the agreed order.
Kenny, do you want to just email that to me and I'll file both at the same time?
I will. That's what I'm going to do right now.
Okay, perfect. And I'll get that e-filed.
All right.
Perfect.
All right, let me know when we're ready to proceed on something. I'm going to work on the matters in the judge's queue on e-filing.
Your Honor, just as a quick question, I don't see Mr. Nitz on the Zoom hearing anymore. We
Yes,
had
he
that.
said his client didn't show up, so.
Okay. Just wanted
But he
to.
would- Yeah, but he said he's available, but so I guess it's just take two sets of prints when Mr. Zamora's booked it in on the failure to appear.
Yes, Your Honor. Just as a clarification, just wanted to let the court know that that's the one that we have set for the sentencing hearing on December 4th.
Right. Well, let's see if he gets caught
Yes, Your Honor.
or shows up. Okay. I'll be listening. Let me know what you need to speak to me. Okay, has a phone number that's a 210 phone number that ends in 459?
It's me.
Okay.
Lupita Fernandez.
Who?
Lupita Fernandez.
All right. What sort of case do you have, man?
I guess it's criminal. I have a possession charge.
I believe she's waiting for Mr. Briggs, sir.
All right. I'll mark you present. I'm going to change your name so we know who you are and mute you again. And
Okay.
we're trying to speak to you. Leave your phone muted, please.
Okay.
Adriana, I'm going to put you on with Mr. Anders now.
Okay.
Brian, I'm going to put you on Mr. Orta now. Is that okay?
Yes, ma'am.
Mr. Orta, are you still with us? You appear to be frozen on the screen. If you can hear us, okay, there he went. Brad, are you available to meet Mr. Baird now?
I am.
Mr. Baird? Mr. Baird, if you can hear me, Mr. Thornton is waiting in breakout room 12 for you. Brad, he never joined the room, is that correct?
He did not.
Okay. I think he stepped away for a moment.
I don't see him in the meeting either, though. Is he here?
I do see him in a box here, just his name.
Oh, okay.
Is the judge available?
Judge Wilson, are you available?
Yes, what's going on?
I just wanted to, I see that Bradley has a little bit of time, it looks like, actually based on nothing that I can see, but so we've got an issue on Mr. Castillo. I know it says MTR, but it's really, I think, a bond forfeiture. That's what I'm thinking.
It's a motion to revoke bond.
Yeah, there we go.
But yeah.
Okay. All right, give me a minute to finish the case I'm working on. We'll be back.
Yes, Your Honor.
All right, calling State versus Michael Castillo. Mr. Andrews, Mr. Thornton?
James Anders for the defense.
I'm here, Your Honor. I'm ready.
All right, and I'll let you know that what I've been doing is going through things in e-filing, and I downloaded the state's motion because that was pending in e-file. Where is Mr. Castillo?
I believe that he is at probation right now.
All right,
Just Don is setting up the room for him. The
Thank you.
office for him.
All right. That, the box that says Anacostia County CSCD, is that Mr. Castillo?
Yes, sir.
All right, go ahead, Mr. Thornton.
Thank you, Your Honor. The state is moving to revoke the bond of the defendant. I've been remanded to custody and ordered a new bond. And I would like to call Brittany Ibarra to testify.
Ms. Ibarra, will you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Go ahead, sir.
Ms. Ibarra, how are you employed?
I work for the 81st and 218th Judicial District. I'm a probation officer.
Okay. Are you also in charge of bond supervision?
Yes, sir.
And are you currently supervising someone by the name of Michael Castillo?
Yes, sir.
And do you see him on the Zoom hearing?
Yes, sir.
And is he the person who has identified as himself as Michael Castillo for the purposes of this hearing?
Yes, sir.
Okay. And is he ordered to be on conditions of bond?
Yes, sir.
And did you go over those bond conditions with him?
Yes, sir.
Is one of those conditions that he refrain from alcohol?
Yes, sir.
And is one of those conditions that he refrained from committing offenses against the state of Texas or the United States?
Yes, sir.
As part of your duties, did you learn that he had been arrested for an offense?
Yes, sir.
What offense was that?
For driving under the influence with a 15-year-old.
Okay. And did you speak to him regarding that?
Yes, sir.
And did he admit to being arrested for that offense?
Yes, sir. He did.
And also, did you attempt to test him or gain an admission from him about his consumption of alcohol?
No, he was honest with me and he admitted that he did use alcohol.
Did he tell you on what date or around what time he used that alcohol?
On the 19th
Of what month?
of October.
And was that while he was currently under conditions of bond?
Yes. Yes, sir.
And on what date was he arrested for that offense?
He was arrested October 19th.
Okay. I'll pass the witness.
Andrews?
Yes. So how many pages is the conditions for bond?
About 1 page.
It's a single page long?
Yes, sir.
Okay. And is that like with 12-point font?
I don't know what font it is.
Okay. Would you guess that it was 12-point font based on your readings of other Word documents that are in 12-point font?
I wouldn't want to take a guess and be wrong. I don't know if it's 12-point font or not.
Does it look smaller than Word documents that you print out?
It looks about normal size from any other documents that we have.
Okay. Now, when Mr. Castillo allegedly admitted to you that he had done some drinking, were there any threats or pressure put on him, or was it more of a question of, did you drink at any point in time?
No, sir. As soon as he got into the office, I asked him how he was doing, and he was completely honest with me, saying that not good because he recently was arrested for alcohol or for driving while intoxicated. And then he admitted to me about using alcohol.
Did you ask him, well, did you drink alcohol?
I did. I asked him if he had any alcohol.
Okay. Did you, and it was only about his consumption, correct? It wasn't, well, had you been drinking? Were you drunk? Like, you didn't ask him anything like that, right?
No, it was just, have you had any alcohol recently?
And he said to you, yes?
Yes, sir.
Okay. No further questions, Your Honor.
Mr. Thornton?
Your Honor, I have no further questions.
All right. Do you have any other witnesses?
I do not, Your Honor. I'll rest my case.
Mr. Andrews?
Your Honor, I don't have any witnesses, just argument.
All right. Who wants to go? Mr. Thornton, are you going? Go
Sure,
ahead.
I have no problem presenting, Your Honor. Mr. Castillo has 3 counts. Theft. I'm currently trying to find the exact bond amounts right now, but I'm unable to do so. However, based on the fact that he has now committed a new offense while he's been out on conditions of bond, we'd ask that his bond be revoked for committing 2 violations against his standard conditions of bond. We ask that a new bail be set in each case. There's 2 of them are third degree felonies. One's a state jail. In the third degrees, we'd ask bond to be set at $50,000 a piece, and on the state jail at $25,000.
And Your Honor, if I may, so at this current stage, the DWI arrest is merely an allegation. So it's basically it's a new number 1 type of situation, and at some point in time, that's going to be argued and fought over and resolved either through plea or through a jury verdict. But as far as his admission to drinking, Your Honor, at this point in time, his bond is a tool to make sure that he appears in court, and he's doing what he's supposed to do as far as appearing in court. Now, I'm sure that there are lots of additions as part of a form that the court has devised that has lots of extra things on there, like consumption of alcohol. And it wouldn't surprise me I haven't seen it, but it wouldn't surprise me if it had something having to do with the ability for probation to send him to some sort of rehab or something like that. That's what seems to be typical of these form probation restrictions. The consumption of alcohol, or which is legal for a person his age, has nothing to do with theft. And when someone is attempting to get out of jail, they sign, as we can all attest to if we're intellectually honest about it, they will sign almost anything. They'll sign that as an accused person, they can have a curfew set by the court on something like a theft. So, while I understand, and appreciate Mr. Thornton's position, I believe that, and I believe that it's in the court's interest that the DWI is an accusation and hasn't been settled and will be settled in the future. And Mr. Castillo is attending court dates like he's supposed to, and going to see Miss Ibarra like he's supposed to, and making phone calls and staying in contact with me like he's supposed to, which is what a bond is for. I think that raising his bonds and putting him back in jail is not the appropriate remedy for the violation of a condition of drinking and alcohol during an abysmal cowboy season. So I ask that the court please take all of these into consideration and allow him to remain on his bond unless or until he commits a violation that the court deems as a serious violation.
Right. Mr. Thornton, anything else?
No, Your Honor, just that he has conditions of bond that say no offense. It doesn't matter the seriousness of that offense. He's not allowed to commit any of them, even if it's a speeding ticket. And he's admitted to the probation officer to violating the conditions of bond in terms of his drinking. And that is a violation whether or not Mr. Sanders wants it to be serious or not. So we would stick with what we're asking for, Your Honor.
Right. Give me a few moments. All right, it looks like I signed an order on June the 16th after a June the 15th hearing that set the state jail felony bond at $5,000 and the third degree felony bonds at $30,000 each. Does that sound correct?
I do recall having a hearing where you lowered the bonds. That does sound correct.
said I incorporated the bond conditions set on June the 15th into this order, and that they're imposed on the defendant. And what amounts is the state asking for?
Your Honor, I had asked for 50,000 on both of the third degrees and for 25 on the state jail.
Okay. And did Mr. Castillo have an interlock requirement placed on him when he bonded out on the felony DWI charge?
I have not received the magistrate paperwork from that yet, so I cannot say for sure.
All right, Mr. Andrews, do you have any insight into that?
No, Your Honor, but if you'd like, you can swear in Mr. Castillo. He's present.
All right, let me just ask you, sir, do you know if there's a requirement in the bond that you received on the DWI charge that you have an interlock device on your vehicle?
Michael, are you required to have an interlock device on your vehicle?
Required?
An ignition interlock requirement on the bond that you made on your DWI? He doesn't recall. He either does not or does not recall, Your Honor.
Usually when they do order that, though, they're sent to probation. Maybe Ms. Ibarra could shed some insight on that.
No, Your Honor, he has not been referred to us by the magistrate on that.
Okay, I will not change the bond on the state jail felony. On the third degree felonies, I will raise the bonds to $50,000 each. So that's an additional $20,000 with the same conditions plus I will check off number 16, the interlock requirement. I'll ask the state to prepare that order and let Mr. Enders have a chance to look at it. Mr. Castillo is in custody until the higher bond is posted.
Your Honor, you said, just to clarify, you said you're not going to raise, are you still going to revoke the bond on the third degree and leave it the same, or?
I'm going to leave it the same on the state jail felony, and I will raise each third degree to $50,000. So that's a net of 20 increase. Plus, I will add condition 16 from the conditions of bond pending trial for a interlock device if he's operating a motor vehicle.
Okay, I'll fill that out and send it to both.
Is that 20 each on each of the?
Yes.
So a total of 40?
Additional, yes.
Additional.
And is there a bailiff at the probation office? Yes, okay, all right. Anything else ready to go?
Judge Wilson, I'd like to let you know that Monica Garza has joined, and she is Mr. Sean King Dawes' client. I don't know if Mr. Dawes is listening. She would like a breakout room with him.
All right, Mr. King Dawes. Is he in a breakout room?
No, sir, no one's in the breakout room right now. Thought I saw him on here still.
Greetings.
All right, if you will contact him.
And then I also see a Michael Terahina joined, which I think we believed he was at the jail.
Judge, that's my case. I had filed a motion to set bond. I confer with the state, and I guess we need a hearing. I have a witness.
All right, give me a moment. Okay, and who's going to hear that on behalf of the state? Who's going to appear on State versus Michael Tijerina? It's a motion for a bond?
That'll be me, Your Honor.
All right, and do you have a copy of that motion, Mr. Orta?
I don't have it. I filed it. I don't have it with me. It's through, I e-filed it. But I don't know how to, I guess get a copy and send it over. I do it through my son.
Okay. All right, Ms. Benavides, could you send me, or Mr. Thornton, if somebody could just post me in chat a copy of the motion?
Yes, Judge, let me look.
I just posted it in chat, Your Honor.
Thank you.
And Judge, this is an MTR. Do you have copies of those? Would you like me to send you the MTR violation report?
Please.
Okay, I've uploaded those as well, Your Honor.
All right, I'm trying to get them downloaded here. Okay, go ahead, Mr. Orta. Actually, wait, is the defendant present at the jail?
Yes, Your Honor.
All right, I don't see. We could get the video turned on. Okay, and I'm asking you to unmute, and is Mr. Tijerina available?
We're getting him right now.
Thank you.
It's already unmuted.
Okay. So we're ready to proceed?
Yes.
Yes, Your Honor. All right, I'll note for the record that the defendant's present via Zoom at the Atascosa County Jail. Go ahead, Mr. Orta.
Judge, I have a witness, Leticia Tijerina. Can we have her called?
Where is she?
She's logged in somewhere.
Okay, is there a Leticia Tijerina present?
I'm right here, Your Honor.
Okay, no, I'm looking for Leticia.
Oh, her last name is Salinas. I'm sorry.
Leticia Salinas?
Yes, sir. She got remarried.
Sir, there is a cell phone logged in, I believe. It's under Michael Terahina.
Should be her.
Okay.
I'm asking a 713 area code phone to unmute. It ends in 443.
Sorry, sir, there's another box that doesn't have a phone number with a name also.
Okay, I'm asking a phone number that with a 713 area code to unmute. Okay, well.
Okay. I'm on. Can you hear me?
Yes, what is your name?
Leticia Salinas.
Okay. All right, ma'am, are you on a phone? Are you on a computer? What are you on?
I'm on a phone.
Okay, I'm asking you to start your video.
Okay.
Will you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Go ahead, Mr. Orta.
Can you state your name for the record, please?
Leticia Salinas.
Okay, and do you know a Michael Tijerina?
Yes, I do.
Who is he?
He's my son.
Okay, do you know he was placed on probation on September of 2016 for an assault case?
I recall.
Okay.
Yes, I recall about that.
Let me ask you, are you employed right now?
No, sir.
Okay, do you know what your income, where were you employed before?
Yes, I was, but the hospital closed down. Yes.
And what kind of work did you do?
I'm a nurse.
Okay, and let me ask you, are you married?
Yes.
And where does your husband work?
He's at the probation office in Georgetown, juvenile detention officer.
Okay, do you know how much he makes?
I think he makes about a month, about $2,000 a month.
Okay, and what kind of bills do you have?
Cars. I have 2 vehicles that I'm paying on. I have land mortgage. I have a tractor mortgage. I have just the regular water, the light, food. I have 2 minor children that are living in my home as well. They are 14 and 9.
Ma'am.
Yes, sir. Yes, sir.
Okay, your audio is breaking up a little bit, and it's difficult enough for the court reporter to take things down over the Zoom meeting anyway, so I'm going to ask you to speak more slowly, okay?
Okay, yes, sir.
Go ahead.
Okay, so I do have 2 minor children who are 14 and 9, still in the home. And I'm just getting unemployment at this time.
How much unemployment do you get?
I get 956 approximately every other week.
Okay, and how much are your bills total? Do you know?
Yes, they're about more than 2,000 a month. I've just been barely like keeping up with all the payments. Like I'll pay one thing 1 month and then call the other people that I'm behind on, tell them that I'll be making partial payments as we go, and they've been working with me.
Okay. Does Michael have any children?
Yes, he has 3 children.
Okay, and at the time he got arrested, was he working?
Yes, he was working. He lost his job because of this issue,
Okay.
because they arrested him.
Was he paying his child support? Does he have child support?
Yes, he pays it every month on all 3 children, every month.
Okay.
He
and,
never, no matter what.
Okay. How long has he been in jail?
Since September 25th.
Okay, and you're asking the judge to set bond in this case?
Yes, I am.
What do you think you can afford on this?
Well, about maybe like 10,000.
Okay, and do you know what kind of probation he is, and regular probation or deferred?
I think it was deferred.
Okay. And that's what more or less you can afford in this case?
Yes, sir.
Okay, and you think your son will show back when given a future date, he'll show up to court?
Yes, he will.
Okay, pass the witness, Your Honor.
Go ahead, sir.
I have no questions, Your Honor.
We rest, Your Honor.
All right, from the state.
Your Honor, I would like to offer the violation report as State's Exhibit number 1.
Right, is there an objection?
Judge, I have not seen the violation report. I don't know if you could post it or.
I've provided that to you in discovery last time you and I spoke, and then also as well today when you and I spoke again.
Right, so do you need a minute to get that, Mr. Orta?
Let me see if it came through.
Let me make sure I went through on my end.
It's through email or?
Yes, through the discovery email that's sent out.
All right, Mr. Orta, I'm sending you the copies I received from Mr. Thornton.
You also downloaded the original one on October 1st at 3:23 p.m. in the afternoon.
Again, Mr. Orta, if you'll look at your chat at the bottom, you should have received copies of those just now.
Let me. Hold on. Lupe, let me ask you something. How do I get something from chat? On report on this one. Let me just.
How do you get what?
A report. How do I?
From the chat. Send it to you.
From the court.
But where is it at? Is it First Amendment, this one?
No.
Yes, that's it.
Okay, this one.
Why did you put this up here? You just
No, it came out by itself.
Okay, let me download it.
See.
Open up. Let's see what's going on.
Or you should be able to just click on it and tell it to download.
It is. That's what we're doing. It's downloading now, sir.
And then hit open.
It just won't open up for us.
Okay.
I'm gonna just
It
go
just won't
back.
open us.
All right, so Mr. Orta, do you wish to go ahead and proceed or?
Yes, Your Honor.
Okay, so do you have an objection to the admission of the motions to the amended motion to adjudicate?
It's on the bond itself, Your Honor. It's not on the for said bond. That's
Okay, but Mr. Thornton has offered the first amended violation report as an exhibit in the bond hearing. Is there an objection to that?
No, Your Honor.
All right, without objection. State's Exhibit 1, is it?
Yes, Your Honor.
Is admitted into evidence. All right, go ahead, sir.
Your Honor, that's all I have. I'll allow the court some time to review that, and then I'll have argument when Mr. Orta's complete with his.
Okay. All right, Mr. Orta.
Judge, this person has been in jail for almost over since September, I think the 14th, somewhere around there. This case is an assault, family violence case. He's undeferred. This case expired this past month on September. I think it's September 12th. He's completed everything on probation, paid everything, and these are the only two allegations on the MTR. I think he's under the law, he's entitled to a bond, and the resources that my client has available is limited. So we're going to ask the court to set a bond at least at $10,000, Your Honor.
Okay. Mr. Thornton?
No, I'd like to refer the court to State's Exhibit 1, where we have the allegations of being in violation of a bond or protective order in terms of a.
Okay, Mr. Thornton, you're breaking up. If you would slow down.
Sorry. It's a violation of a protective order, multiple allegations of the violation of that protective order. The defendant is on bond for assault, family violence, as a result of the revocation of a motion to adjudicate. And so I understand that the defendant is in fact entitled to a bond. However, we would ask that that bond take into account the need for the protection of both the community and the victim, both in this case and in the violation of protective order, where he's alleged to have committed these new offenses while on bond in this case. So we would ask the court to set a bond at $100,000.
Judge, I do have a copy.
Go ahead, Mr. Orta. Go ahead, Mr. Orta.
Okay, I do have a copy of the MTR if that's what we're trying to send. But one of the allegations is vague, is the one on June 13th. And the other one doesn't even, it shows like he just passed by the, what do you call it, by her address. And that's, the street is a regular route. It doesn't show he stopped or anything like that.
All right, and let me ask, is this the first motion to adjudicate that's been filed?
This is the first amended. There was a previous that had been filed. This one just added 2 new allegations to the original.
Okay, and the reason I asked that is it says he was placed on deferred back in 2016, and yet the state's motion to adjudicate alleges that he had a protective order placed against him for family violence in 2019. So that's why I'm wondering
why there was not one before that. Oh, I understand what you're asking. That I don't have a record of. I don't see anything in the file. Maybe probation can shed some light on that.
Probation?
Let me look into it, Your Honor.
Your Honor, I'm Officer Natalie Montiel, and I'm the probation officer. Well, I was the probation officer for the defendant. The
Let me
defendant.
interrupt you, ma'am, and ma'am, let me interrupt you and ask, you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead.
The defendant's protective order came into effect on July 16, 2019.
Okay. But my question is, well, first of all, who is the alleged victim in the underlying offense, the occlusion? Is it the same individual?
No, Your Honor, it is not. The victim on that case is Sarah Tiarina.
Okay.
And the victim in this case is, in the bond protective order, is Crystal Lara.
Okay. All right, anything else from either side?
No, Your Honor.
Okay, I will set a bond in this case at $50,000 and condition it that there be no contact with Crystal Lara. Somebody will get me an order on that. I'll sign it. Plus the other standard conditions of bond.
Judge, I think the motion has an order in the back. But it doesn't have the $50,000 bond on it.
I'll prepare the conditions.
Okay. All right, if you let Mr. Orta have a chance to look at that, thank you.
I will copy both of you.
Okay.
Do we still need a reset date? Is that correct, sir?
Well, it needs a date to proceed on the motion to adjudicate.
May I say something, Your Honor?
No, sir. Mr. Tiarina, if you need to speak, I'll let you speak in a breakout room to your attorney in just a moment.
Okay, thank you.
Or maybe excuse for a few minutes to prepare that and finish on the other order as well.
Yes, and do we have anything else that's ready to go?
Your Honor, this is James Anders. I sent you an agreed order on a Cristobal Estrada. And I think it just needs a few dates put in there and a signature.
Okay. Is she in custody?
She is.
So it says to take her into custody on a certain date.
Does it say take her into custody or does it say to transport her?
It says take into custody, so I'll just put instanter there. Okay, so I'll put instanter on that.
Yes, Judge.
This.
Thank you, Your Honor.
Judge, my client has appeared. Jacob Zamora.
Okay, give me a moment. Okay, I just published or posted to chat the Estrada commitment. Actually, I'm not sure that I posted the right one. Hold on. No, that's the unsigned copy. Give me a moment. Okay, there it is. All right. Mr. Nix, you said your client has appeared?
Yes, Your Honor. He's on the item marked Jacob Zamora.
All right, Mr. Zamora, I'm asking you to start your video.
Yes, sir.
Right. Where have you been, sir?
I apologize. I got my email that I've been at work, but I got my email about the court and I called right away. I apologize, sir.
Okay. All right, Mr. Thornton?
Your Honor, that would be mine.
Oh, Mr. Lamb?
Yes, Your Honor. This is a motion to compel for fingerprints. Does the court have a copy of the motion?
I do.
Your Honor, if you give me one moment. Your Honor, just for the court's understanding, this is a motion just to compel the order for the fingerprints. This case is set for a sentencing hearing on December the 4th. We've discussed with this court that we would be attempting to do everything by Zoom. And as per a sentencing, we would need fingerprints of the defendant to corroborate the judgments and to proceed with the sentencing hearing. So per the court's order that we are to do things by Zoom, the state is asking that we compel the defendant's fingerprints prior to that hearing, and that we have talked with the fingerprint expert and they'd be able to accommodate us and be available on November the 12th at 2 p.m., which is also a court date for Atascosa, this Thursday at 2 p.m.
Right, Mr. Nitz?
Your Honor, we object. First of all, a fingerprint can't be taken remotely. So obviously it's going to have to be taken at one point or another. He was present at the plea hearing. He has had his fingerprints taken at booking, and he will be present at on 12/4. So they can take it on 12/4. And Mr. Lamb couldn't explain why they couldn't just take it at 12/4 when he appeared on 12/4.
All right, is this a open plea? What is this?
He's already pled. And then you pled open, yes.
And your objection again, Mr. Nitz, is?
It's basically just to harass him and add additional things. Like he said, he was at work today. He's got work to do. And we're asking that he be allowed to take the fingerprints on the day that he comes in for the hearing. Again, he's already had his fingerprints taken at booking. He's been present for the fingerprints, and just because they weren't prepared at that point, they can take it when he comes in.
Well, I mean, you could also just stipulate that he's the person in the other judgments, if that's what the fingerprints are going to show.
And Your Honor, the state has asked Mr. Nitz to stipulate.
All right, I will order Mr. Zamora to be at probation 2 p.m. on the 12th of November of this year to have his fingerprints taken. I'm signing that order right now.
Thank you, Your Honor.
May we be excused?
Yes.
For clarification purposes and for Ms. Poppy, this would just be, the state is asking for a reset, basically for check-in at 2 p.m. on Thursday, in case the defendant is to not show, the court has the ability to issue an ISI.
Yes, it's set. The case is set for 2 p.m. on Thursday. Is it Thursday?
Yes, Your Honor. 2 p.m. on Thursday, yes.
Thank you.
And I'm about to post that in chat. My computer doesn't lock up.
Kenny, are you available to go to a breakout room?
Yes, I am. Who would it be with?
Mr. Cabanas.
Okay, yes. Oh, okay.
All right, I just did that. What else do we have ready to go? Mr.
Judge, can my witness be excused, Ms. Salinas?
Yes, your witness is excused, and you need a breakout room with your client?
I'm just waiting for the order, but I need a breakout room.
All right, if you'd address that to Ms. Poppy?
That would be with the jail, correct?
Yes, he's still there.
Okay.
All right,
Mr. Orta, I'm emailing you the standard conditions of bond the judge asked me to confer with you with, as well as to the court right now.
Thank you.
All right, Mr. Shaughnessy, do we need to discuss anything?
No, I believe we're ready if my client's still in probation, Your Honor.
Ready for what?
It's a motion to revoke. We have an agreement with the state. Jose Martinez.
Agreement with the state for what?
And a motion to adjudicate, Your Honor.
Okay, I don't have any paperwork on that.
Well, it was, my client signed it in the probation department.
Okay, well, I'm not saying that you should have had it to me. I'm just letting folks know I have no paperwork on that. So we'll be in recess until 11:45. I'll be back with you.
Judge, if I may, before you go, I just want to let you know Monica Garza is here.
Yes.
And on her case, we're going to set it for a trial date. Because,
okay, get that from Ms. Poppy.
Okay, thank you, Your Honor.
Also, Your Honor, I believe Mr. Shaughnessy is here. I don't know if he's announced.
Yes, he just announced he's ready, and we're
okay.
Locate the paperwork that was signed.
Yes, Your Honor. Sorry, I was in the breakout room. I wasn't sure.
That's
Thank you.
fine.
Mr. Briggs, if you need a breakout room or anything, let me know, please.
Hello? Yeah. Hey, why didn't you tell me?
Mr. Orta, were you gonna rejoin the breakout room with the jail?
Yes, I need to
Okay, let me
talk to him for a quick,
Let me send y'all to a new breakout room. 1 second.
okay, thank you.
Judge said 11:45, right?
Yes, I believe so.
Okay.
No.
Mr. Orta, you should have received an invite to room 16.
I don't see it yet.
You may have to hover over your screen at the bottom until you find breakout rooms.
Okay, I got it.
Mr. Orta?
Yes.
Just so you know, sir, I've sent you 2 available dates for your reset. If you would like to check those, I put those in chat to you.
Okay, hold on. Can you hear me?
Yes, sir.
The 12/14, the latest would be good.
Okay, sir, so we want you to post that back in a certain format. And we want you to post the cause number, defendant's name, and the date you have chosen.
Okay.
So we have that for record.
Okay, thank you.
Thank you.
Uh-huh. Hello? It's something they sent me on conditions of bond.
Okay, on Jose Martinez, I have the judgments, but I do not have or they sent to me in chat. I do not have the plea papers.
Just sent the judge, and I just made a notation as well that the plea paperwork was not in order.
Oh,
Okay, let me see. Thank you, it just came here.
and I guess as a clarification, Your Honor, if just wanted to know if the attachments were on that document from Chris. If not, I can get them sent.
It's still downloading. Let me see.
Mm.
Okay, and let me ask Ms. Benavides, where did these documents come from?
The defendant brought them to our office, Judge. So I have no idea if this is all that
Okay.
we're supposed to be with it or not.
All right, I will delete all of well, no, I will not do that. Okay, I'm gonna ask somebody to put them in order. There's 58 pages, and I don't intend to go through and
Yes, Your Honor. If Ms. Benavides, if you can send it to me, I'll get it in order.
Absolutely.
I don't think a lot of it is needed, but. Okay. And have we heard from Williamson County? Were they supposed to be signing on?
Judge, I was waiting for Mr. Sean King Dawes to inform me, but they can be on at noon today. They're running a little behind, so about 10 minutes.
Okay. Expect any other pleas today?
No, Your Honor, none for me. I don't think Mr. Lamb has any either.
None for me, Your Honor.
All right.
Your Honor, I've done the redactions on it. I'm going to be sending you, Ms. Benavides, and Mr. Shaughnessy a copy of it. It was just sent, Your Honor.
Give me just a moment.
Sure.
Judge Wilson, there's a handful of cases today I don't have recent dates on that I believe the attorneys probably just posted to you directly. So just wanted to give you a heads up there.
Okay. All right, did you email that?
Yes, Your Honor. I'm sorry.
All right, calling State versus Jose Alfredo Martinez. Are both sides ready?
State's ready.
Bench ready, Your Honor.
Okay.
My client's at probation.
Right. Are you Jose Alfredo Martinez?
Yes, sir, I am.
Okay. Are you the same Jose Alfredo Martinez who on or about February 16th, 2018 was placed on 10 years deferred adjudication for 2 first-degree felony counts of possession of a controlled substance within with intent to deliver, and 1 second-degree felony count of possession of a controlled substance with intent to deliver?
Your Honor, I believe it was 10 years probated for 10 years.
Okay, I'm sorry. It wasn't deferred. It was 10 for 10 on all 3 counts. All right, so let me back that up. Are you the same individual who was placed on regular probation after having been found guilty of 2 counts of first-degree felony possession of a controlled substance with intent to deliver, and 1 count of a second-degree felony possession of a controlled substance with intent to deliver?
I think you're correct, sir.
Okay, well, I need to make.
Yes, sir. Yes, sir. You are correct. Sorry.
All right. And you understand that if you successfully do everything you're supposed to be doing in your probation, that you will never have to serve any part of that underlying 10-year sentence, except for anything okay. But the state has alleged that you have violated the rules of your of your probation. Got deferred in my mind. And if that is true, then the probation of that underlying 10-year sentence could be revoked, and you could be sentenced from 2 to 10 years in prison, plus to any unpaid portion of your fine.
Yes, sir.
All right. Let me see here. The state is proceeding on rule number 17. And there are, while you were on deferred adjudication, pardon me, I don't know what the hell's wrong with me this morning. While you were on probation in the months of March through December of 2018, and during every month in 2019, and in January and February of 2020, that you failed to complete the 16 hours of community service restitution you were supposed to complete every month? So do you understand what the state's alleging that you did wrong?
Yes, sir.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea?
No, repeat that, sir. I caught everything but the last part. I'm sorry.
All right. Now, it's my understanding that you have worked out an agreement with the state. That's called a plea bargain.
Yes, sir.
I don't have to follow that plea bargain.
Correct.
If they know I'm not going to follow it, I will let you take your plea back.
Yes, sir. Correct. Okay. Yes, sir.
And if I do follow the plea bargain agreement you have with the state, and the sentence I impose is not what you've agreed to, you understand that you will not be able to appeal this matter?
Yes, sir.
Okay. All right, I want to show you some documents that appear to have your signature.
Yes, sir.
They're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. And is that what's appearing on the screen, folks?
Yes, yes, sir, it is.
All right, like I said, you can't see it anymore on Zoom. I want to ask you, on page 3, is this your signature?
Yes, sir, it is.
And do you swear or affirm that everything that appears above your signature on page 3 is true and correct?
Yes, sir.
Did you also sign where it says plea bargain agreement?
Yes, sir, I did.
And on page 2 of the waiver of time to file motion,
Yes, yes, sir, that is my signature.
certification of appeal?
Yes, sir. Excuse me. Sorry about
Did you read these documents yourself, or did your attorney, Mr. Shaughnessy, read them to you?
Yes, sir. Mr. Shaughnessy went through them, and I took some time to read them over myself also.
All right. Did you understand these documents before you signed them?
Yes, sir.
Okay. And are you satisfied with the work that your attorney has done for you?
Yes, sir.
Counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I do, Your Honor.
All right. And I'll find, sir, that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you to the allegation that you violated Rule 17 of your probation by failing to complete your community service hours. Is that true or not true?
That's true.
All right. I'll accept your plea of true and ask what evidence the state has.
State tender States Exhibit 1 and its Attachment A, along with Attachment A, Your Honor, on counts 2 and 3, the violation report and the motion to revoke our identity to count 1.
All right. Is there any objection?
They've been provided, Your Honor, in discovery, no objection.
Okay, I will, without objection, I will admit the state's exhibit and its attachments into evidence on all 3 counts. To both sides rest and close at this stage?
State rest and close.
Yes, Your Honor.
All right, I'll find that the state has substantiated the violation that was made. Are both sides ready for punishment?
State's ready.
Yes, Your Honor. Defense ready.
Is there a pre-sentence investigation report or a waiver of one?
I don't believe there are any additional reports, Your Honor. We would waive any need for any further.
All right, has there been one done?
I assume there was one done at the time of the plea.
Right, but I mean, since then.
Not to my knowledge.
Okay. All right, what is the plea bargain agreement in this case?
The plea bargain in this case, Your Honor, is for 7 years in the Texas Department of Criminal Justice Institutional Division on count 1, 7 years on count 2, and 7 years on count 3, all running concurrently with 17 days credit on each.
All right, so you heard what was read in the record by the state's attorney. Is that your plea bargain agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
Not to my knowledge. I think yes, sir. He did not leave anything out.
Okay, and did he add anything?
No, sir.
All right. Anything else from either side?
Nothing from this side.
Just one thing, Your Honor. Oh,
I'll bring it up when we're in
yes, sir. Okay.
a second.
All right, give me a moment.
Sorry about that, sir. It's kind of weird with the whole video thing.
You think?
All right. And are there new cases pending against Mr. Martinez?
Yes, there are, Your Honor. I've discussed those cases, and those will be dealt with whenever they are actually presented to us.
Okay, meaning that this plea bargain does not incorporate them at all?
It may, it may not, Your Honor. It is one of those that we would have to discuss whenever the cases are actually filed and what type of cases are being.
Okay, all right. And you had something else, Mr. Shaughnessy?
Yes, Your Honor. We understand that the court is in the position of sentencing my client to 7 years in the Texas Department of Corrections. He asked me to inquire of you whether you would be amenable to having him report to the Sheriff's Department a couple of weeks down the road before he is shipped to TDC.
State would object to that due to the fact that this case has been reset multiple times, at least in the recent history, let alone that this case has been on the docket for an extremely long amount of time, Your Honor.
Right. And what's the particular reason, Mr. Shaughnessy?
I think Mr. Martinez would have to elaborate on that, Your Honor.
All right, go ahead, sir.
I'm because of this whole process, I need to move my son and his mother into a smaller house, and we're planning on doing that this week. Today might have been the last day, so I really need to move them to get them situated, and just so I could not worry about them and have them in a better house for when I'm gone. And I mean, even if it's just 1 week, I mean, if possible, I mean, I've never missed a court date or never. I mean, I have no objection turning myself in. But in all fairness, I mean, if it's not possible, it's not possible. I just, you know, even if it's just 1 week, that way I can move her to a smaller house.
All right, give me just a moment.
Yes, sir.
All right. And how long has Mr. Martinez been out on bond on the motions to revoke?
Yes, he has, Your Honor.
For how
The
long?
motion.
How long?
I think it's going to be March, sir.
Yes, Your Honor. The motion to revoke was filed in March of 2020.
All right. I will allow Mr. Shaughnessy and Mr. Martinez to speak in a breakout room if you want to. What I would be prepared to do is to convert this to an open plea and set it to be finalized Monday. And what that would mean, sir, is that if you show up for court on Monday and you have not violated the terms of your bond during the 6 days or during the week that it's going to pass by, then I would follow the plea bargain agreement and sentence you to 7 years. But if you fail to appear, if you use alcohol during the next week, if we find out that your concern is to perhaps engage in some sort of transaction that might bring you a large amount of cash and you get caught doing that in the next week, then you would have an open plea, meaning that I could sentence you to up to 10 years on each of these cases. You want an opportunity to speak to Mr. Shaughnessy about that?
I mean, I could talk with him, but I'm totally.
All right, Mr. Shaughnessy, do you want a chance to talk to your client in a breakout room?
I would go along with that week. I feel confident that I will not.
All right, and Mr. Shaughnessy, are you still there?
Yes.
Okay, all right. Do you want a chance to speak with your client in a breakout room?
I don't think I could elaborate on it more than the court has, Your Honor.
All right, sir, I've got to tell you, I'm very concerned that it's not just that there's allegations that you were using drugs while you were out on probation for this, but there's allegations of new offenses of possession with intent to distribute first-degree felonies.
Yes, sir, totally understandable.
So the only stick I have is 3 additional years, but you should not put me in a position where I'm wondering if I need to use that stick. So I will set this for finalizing the plea on Monday, the 16th, is it?
Yes, Your Honor. That would be the original one that had the trial date, but
yes,
Your Honor, that is the 16th.
Okay. All right, so that's set for the 16th.
Yes, sir.
16 for entry of sentencing. I'll see you then.
Is that going to require redoing the paperwork, I assume?
No.
No.
I mean, well, yes, if there's an issue, then yes. I don't know if it'll require redoing the paperwork. I'll just put a notation on the plea bargain agreement it was a change to an open plea. And in fact, I will post that back in just a second, and I will ask you to have your client sign that electronically there at the probation office. Give me just a moment. Thank you, ma'am. Give me a moment to sign the first part of this, and then I will post it. Thanks a lot.
Judge Wilson?
Yes, ma'am.
I have a suspicion that Williamson County is on. It just wasn't under a name I recognized.
Wilt's name, yes.
Okay.
I see somebody in there. I assume that's what's going on.
Yes, this is under Elena Wilkes. I don't know why, but Williamson County is on.
All right, I just posted the Martinez plea bargain documents back. I'm going to ask the probation just to open that up as a PDF and for Mr. Martinez to put his initials on the change I made on the plea bargain agreement to say that it's an open plea in exchange for being allowed to report on the 16th. And that way we don't have to scan anything back in. I will hold on to the judgments and I will change the dates on those.
Yes, Your Honor.
Okay, so what do we have next? Brandon?
Judge, I have a quick question on Tijerina.
Yes.
I saw the copy of the conditions of bond. Does he have to sign it today or if he makes bond?
Just whenever, it doesn't matter to me.
Okay.
I don't have a dog in that fight, as long as it happens.
Can I be excused, Your Honor?
Yes, sir. We'll see you on Monday.
Can I be excused, Judge?
Yes, sir.
Thank you, Judge. Bye.
Okay, and do I have the judgment on Brandon?
No, Your Honor, I haven't sent. I was waiting to find out if he pled guilty or no contest.
Okay, that's fine. That's fine. All right, calling State versus Brandon Harding. Are both sides ready?
Defense is ready, Your Honor.
State's ready.
Right. Give me just a moment to.
Can you hear it okay?
Can you hear me? Is that what you said?
No, I'm asking if you can hear him.
Oh, yeah.
Okay, are you Brandon E. Harding?
Yes, sir.
All right. Mr. Harding, can you speak, read, and write the English language?
Yes.
Are you a United States citizen?
Yes.
All right. Despite your representation that you are a United States citizen, I need to caution you that if that is not true, a plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
No.
Counsel, do you believe your client is competent to stand trial?
Yes, Your Honor.
All right, sir, you stand charged by indictment with the third-degree felony offense of theft, $30,000 to $150,000. Specifically, it's alleged that on or about December 19th, 2019 in Atascosa County, that you unlawfully appropriated by acquiring or otherwise exercising control over a vehicle. The value are $30,000 or more, but less than $150,000 from Casey Bud Privet, the owner thereof, without that owner's effective consent and with the intent of depriving the owner of the property. That alleges a third-degree felony, which is punishable by confinement for not less than 2 and not more than 10 years and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea?
Yes.
And if I do follow the plea bargain agreement in this case, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Yes.
And you understand that if your plea bargain is for deferred adjudication probation, and I should decide to follow it, I would find there's enough evidence to say you're guilty, but I would not do so. Instead, I would place you on deferred adjudication probation. And if you successfully complete that deferred adjudication probation, the case against you will be dismissed, and you may even be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were ever arrested. On the other hand, if while you're on deferred adjudication probation, the state alleges that you have violated the terms of it, then you could be arrested and brought back to court, and there would be a hearing on just that question. Did you violate your deferred adjudication probation? And if the answer turns out to be yes, then you could be found guilty and sentenced to anything that is a legal sentence for a third-degree felony, that is anywhere from 2 to 10 years in prison, and a fine up to $10,000?
Yes.
All right. I want to show you some documents that appear to have your signature.
Okay.
They're titled Admonition to the Defendant for Plea to the Court. And let me ask you, on paragraph 2.11, is this your signature?
Yes, sir.
And on page 5 where it says verification?
Yes, sir.
And do you swear or affirm that everything above your signature where it says verification is true and correct?
Yes, sir.
Did you also sign on the certification of appeal?
Yes, sir.
Agreed punishment?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And discovery certificate?
Yes, sir.
Did you read these documents yourself, or did Mr. Keendahl, your attorney, read them to you?
Yes, I read them and he went over them some with me as well.
All right. Did you understand these documents before you signed them?
Yes.
And are you satisfied with the work your attorney has done for you?
Yes.
All right, Mr. Keendahl, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
All right, sir. I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily. And I will approve them, and I'll ask you, to the allegation in the indictment, third-degree felony theft, do you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No, sir.
Has anyone harmed or threatened you or anyone close to you for your plea?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
All right. I'll find that you made your plea voluntarily and you're not under any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has.
The state offers Exhibit 1 and its Attachment A.
No objection, Your Honor.
All right. Without objection, State's Exhibit 1 and its Attachment A are admitted into evidence. Do both sides rest and close at this stage?
State does.
Defense also, Your Honor.
All right. Give me a chance to look this over. All right, I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for punishment?
Defense is ready, Your Honor.
State's ready.
Okay. All right. Is there a pre-sentence investigation report?
We can waive that, Your Honor.
All right. What is the plea bargain in this case?
The plea bargain in this case is for 5 years for adjudication with a fine of $1,000, restitution of $250, court cost of $315, drug test fee of $50, and a monthly probation fee of $60. 200 hours of community service.
You're breaking up, sir. Mr. Thornton, you're breaking up. After the probation fee, it broke up.
Probation fee, there's 200 hours of community service, education, drug, alcohol evaluation, and follow recommendations, your driver's license suspension, and 90 days of residential treatment facility.
All right, sir. Did you hear what was read in the record by the state's attorney?
Yes, sir.
Is that your plea bargain agreement with the state?
Yes.
Did the state's attorney add anything or leave anything out?
No.
All right. Anything else on either side?
Nothing from the defense, Your Honor.
Nothing from the state.
Okay. And the charge that Mr. Brandon's being held in Williamson County, does that have to do with fleeing from a peace officer with the vehicle in question?
It does, Your Honor, and he had a sentencing hearing there where the judge gave him this sentence, and so we agreed to this plea bargain to basically reincorporate the sentence in our county.
All right, then I'll find I have enough evidence to make a decision in this case without a precedence investigation, and I'll proceed. All right, then I will follow the plea bargain agreement in this case. I'll find, sir, there's enough evidence to say that you're guilty, but I will not do so. Instead, I will place you on deferred adjudication probation for a period of 5 years. And please keep in mind what I said, that if you do everything you're supposed to do, the case against you will be dismissed. You'll have no conviction. And you may be able to get an order of non-disclosure to keep anyone except law enforcement from being told by the state that you were even arrested. On the other hand, if while you're on deferred adjudication, if you are accused by the state of breaking the rules, then you could be arrested, brought back to court, and there would be a hearing on just that issue. Did you break the rules? And if the answer to that is yes, then you could be found guilty and you could be sentenced from anywhere from 2 to 10 years confinement and fined up to $10,000. And where do you expect you're going to be residing?
In Falls City.
Okay. So you'll be in Karnes County?
Atascosa County.
Atascosa County, okay. All right. Well then, I want you to keep a couple of things one thing in mind. I'm not telling you that it's not important that you make all the payments you're supposed to make. In this case, it is important that you make those payments. But if the only thing that you're not doing is you're not making 100% of the payments on time, you're not going to be adjudicated guilty just for that. We would give you a chance to make larger payments if necessary towards the end of the time you're on probation. And if absolutely necessary, you could even be extended. So I want to make sure that if a month rolls around that you can't make a full payment, that you don't fail to go and see your probation officer just because you don't want to tell them you don't have the money, okay? Make sure you follow all the rules.
Thank you, Your Honor.
Whether you've got the money or not, show up and see your probation officer.
Okay.
All right, so I will post this back.
As far as a hold that I have here from Atascosa County after today's hearing, will that be lifted?
Thank you for bringing that up. Yes. I would also request that any warrant be recalled after the completion of this plea.
All right, well, we need to get a thumbprint, but yes, that should happen. And now, are there any other cases from Atascosa County?
No.
No.
Okay, yes, sir. If this is all you have, then it will be released.
Mr. Keen-Dawes has been in contact with the authorities at Williamson County. So once I emailed the judgment to the judge, Your Honor, if you would just forward that to both me and Mr. Keen-Dawes, he can get it to the authorities. And once that's complete, then the warrant will be lifted.
That's good. Pardon me. All right, is there anything else we have going on the criminal side?
No, Your Honor, if you want to go over the docket, I have a few things that I'm missing.
Your Honor,
Okay.
for Jose Martinez on the plea agreement or plea bargaining agreement page, I believe it's page 5.
Right.
It says open plea in exchange for allowing defendant to surrender 11/26/2020. Is it 11/26 or 11/16?
11/16, that's a typo.
Okay. If we can just resend it so I can get them to initial that page, correct, Your Honor?
Yes, give me just a moment.
Judge, can Williamson County be excused?
Yes, absolutely. Now, have you been sent anything that you can to get a thumbprint on?
To my knowledge, not yet.
Okay, I mean okay. All right. If you'd hold on just a moment, Mr. Thornton, if you'll send them just a thumbprint page or somebody, post that in chat. Let me ask Williamson County, do you have a way to download anything that's in chat?
Oh, in chat.
We could receive it via email. We do not have anything to download it via chat.
All right. Okay, well then I guess you're excused. You'll have to follow up and get the thumbprint, Mr. Thornton.
Can I get that email from you so I can copy it on the string?
It's jail.teams@wilco.org.
jail.teams@wilco.org.
Yes, sir.
Okay, we'll be sending that here in just a minute.
All righty, sir.
Okay, I just sent the corrected Martinez plea papers. Thanks for catching that.
Thank you, Your Honor.
All right, as far as going over the docket, I need to take a break. Letty, we need to be back at 1 o'clock. So I will go over the docket later. I'm going to ask the Ms. Poppy if you'll go over it with the state, and I'll be back before 1 for the start the Peeler case.
Okay, sir.
Yes, Your Honor. Have a good day.
I'm going to email you the judgment if you just want to. I'm going to copy the Wilco if you just want to forward it to him and to Sean King Dawes so that way they can get the prints.
Sounds good.
Thank you.
Okay, thank you, Judge.
So, Jennifer, and I
Yes,
guess probation as well. If we can, Michael Tijerina, I don't have a date.
12/14.
12/14, okay. Jose Martinez was reset for 11/16 for final sentencing.
Mm-hmm.
Jacob Zamora is reset for 11/12 at 2 p.m. for fingerprints. The state will ask for a NISI on Bernadette Cuellar. Rafael Tijerina, I don't have anything.
January 19th, 2021.
Okay, January 19th. Justin Peacock, reset to 11/12.
Mm-hmm.
Kathy Green, reset to 1/11/2021.
Yes,
Sandos, I don't have anything.
I don't either. I think they may have sent it directly to him.
Okay. So we'll have to get back on that one. Unless, does probation know?
No, we
Or-
don't have anything on there.
Okay. Or Chris, do you know of anything?
No, Kenny.
Okay. Ernesto Velasquez,
12/14.
12/14.
Yes, sir.
Okay. Andrew Serta was 1/11/2021. Jesse Fernandez.
I need to follow up with Judge on that because it was not posted to me.
Okay. Nobody else has anything?
No.
Okay.
No.
Garcia was 12/7. Kevin is 12/7. Thurman is 12/7. Booth is 12/7. Jack Cedillo is 1/11/2021. Lupita Fernandez is 11/12/2020. Monica Garza is 1/11/2021. Hilburn 1/11. 2021. State's asking for a nice eye on Abby Oliva. Palma 111. Carlos Sainz 111. True Love 111. Darlene Hatfield 111. Kubish 111. What happened with did Mr. Cox get with you on Justin Schaefer?
Yes, we have 12/15/2021. Let me make sure it's the right date. 12/15.
2020, right? This year?
Yeah, 2020. So I think I had 111 at first. Let me make sure.
Okay.
12/15 is not a good date.
It's not?
No.
Okay.
It's supposed to probably choose the 14th or 16th. While you keep going on, let me double check the note in chat.
Okay. Whichever date's fine with me. We'll just need just to make sure that we can get if we need a bench warrant, to get a bench warrant done. If not, we need to figure out what needs to be done. Brandon Harding was final judgment. Michael Castillo, bond was revoked, but does he have a new date or?
He does not. I asked Mr. Anders about that after he had gotten off, so him and I were back and forth via email.
Oh, okay. That's fine.
But he said 11/23 if he needed a date. He wasn't sure if he needed a date.
Okay. I'll put 11/23 on our docket just as a tentative.
Okay.
Perez was a 12/7 and Spain is a 12/7.
Mm-hmm.
And then on the civil side, David Arocha was dropped and Adrian should have sent an order to the judge. Cristobal Estrada order was filed for incompetency.
Can't hear you for some reason.
Oh, on Estrada, the order for incompetency was filed.
Did you go over Underwood?
Oh no, and then Underwood was an agreed motion to reduce bond and it was dropped.
And then on Estrada, do we need any kind of monitor date on that?
Yes, it's 120. The order that I had sent over to Mr. Anders and we had gotten signed. Let me pull it up just to make sure. It was a commitment order for 120 days.
Mm-hmm.
So if we could get a reset date, let's see, 4 months out. No, that's actually 4 months. So 3 months out. So 90 days.
That would be on 2/8/2021.
And that would put us, if we need to refile or do anything else. So yeah, I would ask that 2/8 be a reset date for him. Monitor
Let me check on the case with Lee Cox real quick.
Okay. And that should be everybody after Mr. Cox's case.
I wrote it down wrong. He did message me the 14th.
12/14? Okay.
12/14.
Perfect. And Mr. Cox has been pretty good about getting in contact with me, and we'll keep discussing because it will be how we're going to get him back because he has cases elsewhere as well. To my discussion with him, so he's been sent to the Luther unit and then ripped out and then taken to some other county, and then we can't take them from there. They have to go back to TDC and then the moment they get back to TDC, he gets pulled somewhere else. That's been kind of the problem with this defendant.
So the two we don't have dates on are that Frank Sandoz.
Yes, I don't have
and
Frank Sandoz or
Fernandez.
Jesse Fernandez.
Okay.
Perfect.
I
And
believe that's
Brittany,
it for the criminal file. I don't know if he still needed to speak with anybody.
I do not know, but Brittany, I will. I already talked to Lotta about that. I will get with our girls over here.
Sounds good.
Do you need me for anything else?
I don't
Anybody?
believe so.
All right. Well, thank you very much. Have a good one. Take care.
Thank you.
Give me just a moment.
We can do that. Because we're technically still muted. That.
Give me just a moment. Okay, Verslicki and the other one, which motion is going first?
Your Honor, I'll start with the motion regarding Jeremiah McKinney.
All right, so let me ask San Miguel versus Peeler, or is both sides or all sides ready?
Peelers are ready, Your Honor.
We're ready, Your Honor. For Jeremiah McKinney, Lewis Sutherland, Ferguson, and Elkins will be arguing today.
Yeah, I just unmuted him. Yes, Your Honor. Cody Schneider on behalf of Kiewit Mining Group is ready to move forward as well.
Okay.
Yes, Your Honor. And were you able to review the briefing, or would you like us to put that in chat for you?
I downloaded it. I have not had a chance to review it.
Okay, thank you, Your Honor. So San Miguel has designated Jeremiah McKinney, who is a wildlife biologist and a consultant for San Miguel, as an expert to provide 3 separate opinions. We are challenging all 3. And Your Honor may recall that Jeremiah McKinney was subject of a motion to compel, and Your Honor has already limited his opinion to what has been disclosed because he relied on his general experience at San Miguel, including surveys that were not disclosed to us. So Mr. McKinney is a longtime consultant to San Miguel who provides endangered and threatened species surveys for permit filings, along with assistance on bond release packages with respect to evaluating the percentage of established grasses in what are called land management units. That's how mined property is divided in the mine permit for the purposes of evaluating reclamation and bond release into land management units. Mr. McKinney's first opinion in this case is that San Miguel's reclamation activities are regulated by the Railroad Commission of Texas Surface Mining and Reclamation Division, which he claims enforces rigorous revegetation performance standards to prevent erosion and ensure adequate productivity capability for post-mine land use. This opinion should be excluded because Mr. McKinney's understanding of the law applicable to the reclamation activities on the Plea Ranch is irrelevant. An expert may not testify on pure questions of law. Thus, an expert is not allowed to testify directly as to his understanding of the law. And yet that is exactly what Mr. McKinney does in his first rendered opinion. He explains that San Miguel's reclamation activities are regulated by the Railroad Commission. He characterizes those regulations as rigorous, and then he explains his understanding of the regulation's purpose. He does not actually provide any opinion specific to how those regulations are applied to San Miguel, just his general understanding of the regulations. And the court cannot permit Mr. McKinney to invade its own province, explaining the law to the jury, and then add his commentary on the sufficiency and purpose of that law. Also, Mr. McKinney tenders this opinion on applicable law as an expert wildlife biologist. He has a Bachelor of Science in Wildlife Biology from Texas State University. Nowhere in their response to the motion to exclude Mr. McKinney's testimony did the coal companies attempt to show Mr. McKinney's qualifications as a legal expert. And indeed, he is not a legal expert. For this additional reason, testimony as to his first opinion may not be admitted at trial. Also, the Peelers have sued San Miguel for breaching its restoration obligations under the mineral lease. Mr. McKinney admits he has never read the mineral lease. He also testified that he is not offering the opinion that the mineral lease restoration standards and the Railroad Commission's bond release standards for reclamation regarding grasses or anything else are the same. The fact that San Miguel's reclamation activities are regulated by the Railroad Commission has no bearing on answering the question before the jury, which is, has San Miguel breached the financial or restoration obligations in the lease? So for that additional reason, his first opinion should be excluded as irrelevant. It will only serve to confuse the jury. And here, Your Honor, I just point out that with the ruling on the economic loss rule, San Miguel is attempting to have it both ways. Not only is San Miguel trying to limit the peelers to lease damages within the lease area, but it's also trying to have all of these experts testify as to Railroad Commission standards and reclamation standards, which are not incorporated into the lease, as a way of forgiving any breach of lease because the Railroad Commission standards may or may not have been met, and we think that's inappropriate. Mr. McKinney's second opinion in this case is that the land San Miguel has reclaimed, other than the land affected by the salt seeps, are, quote, highly productive for use as pasture land and, quote, provide valuable habitat for grassland species. This opinion is also irrelevant to the issues that will be presented to the jury at trial. Whether San Miguel's reclamation efforts have resulted in land that is highly productive as pasture land, as that term is defined by the Railroad Commission, or as good habitat for certain animal species, which is really the crux of Mr. McKinney's opinion, will not assist the jurors in determining whether San Miguel has complied with its contractual obligations to restore the land under the terms of the mineral lease. Mr. McKinney spends significant time in his report discussing how mining generally increases grassland habitat for threatened and endangered species because it removes shrubs like mesquite and huisach. He opines at length about how this increased amount of grassland habitat has improved the population of the monarch butterfly and certain reptiles and migratory bird species. But whether or not the monarch butterfly population has improved over its range has no bearing on any material fact or issue in this lawsuit. Notably, none of Mr. McKinney's opinions on this point are specific to the Plea Ranch. He cannot even state for certain whether he has seen any of these species on the former mined areas in the Plea Ranch. And he certainly hasn't evaluated whether their populations have improved as compared to before mining, meaning there's no reliable basis for this opinion. In addition, his second opinion lacks a reliable foundation with respect to the one mathematical analysis he did. Mr. McKinney states in his report that his review of the land management units wholly or partially on the Peeler land shows a mean ground cover of 97.9%, which he states exceeds the mine-wide ground cover standard by approximately 7%. And what he did to come up with this number was to take phase 1 bond release letters from San Miguel to the Railroad Commission, where San Miguel is representing to the Railroad Commission how much ground cover percentage has been achieved in a certain land management unit by that date. Mr. McKinney took those letters, which range from 1995 to 2010 for all of the land management units located on the Peeler Ranch or partially on the Peeler Ranch. And he added up all of the ground cover numbers for the different land management units and then averaged them. Those phase 1 bond release letters span 15 years. And the whole purpose of having 3 phases of bond release is to make certain that ground cover is self-sustaining at the end of phase 3. So the phase 1 ground cover estimate proves nothing except that at that point in time, San Miguel represented to the Railroad Commission that a certain percentage of the ground in the land management unit had grass cover. When I asked him, and have you gone back out to the ranch and done any survey to analyze whether that ground cover remains at 97.9% average today? He answered, no. And when I asked him, so how is that a scientific methodology to average the ground cover production from various points in time across properties to come up with a current ground cover average? He answered, I don't believe the report ever states these data represent the current conditions. And of course, that's critical because we're in this lawsuit talking about the current conditions. Now, to the extent he attempts to buttress his opinion at trial based on his prior experience with San Miguel or some later analysis that wasn't disclosed, that's precisely the type of opinion the court already has held Mr. McKinney should not be permitted to offer at trial. Basically, Mr. McKinney is assuming or speculating that the ground cover San Miguel claimed to have achieved in a letter to the Railroad Commission for phase 1 bond release for a specific land management unit is substantially similar today in 2020. Importantly, Mr. McKinney has done nothing to test this assumption. When I asked him specifically, have you done anything to test that assumption? He testified, no. And he admitted he did not and could not account for differences in ground cover estimates between historical data and present conditions caused by any spills or contamination over time. When I asked him, I ask you to assume in areas A10 and A11 that there has been a spill of hazardous substances on the surface of the land. How would you be able to tell from this table and these letters that predate the spill that the grass is at the same level of 100% productivity in those areas? He answered, I do not think that the data, I would not be able to do that for obvious reasons. I don't have the ability to the data. If the data predates any sort of spill, then you couldn't use that data to evaluate any location where a spill had occurred. So even if the grass cover was actually productive at the phase 1 bond release, Mr. McKinney has no way of knowing whether that is true today or how any area has been impaired by San Miguel's action or lack of action between the time of the phase 1 letter and trial. The data underlying Mr. McKinney's analysis cannot provide reliable support for his conclusion that the Peeler's reclaimed land is highly productive pasture land and provides valuable habitat for grassland species. Any expert's opinion must be based on reliable foundation, and yet his opinion about the current state of the reclaimed land is based on data that is between 10 and 25 years old. And Mr. McKinney admits the data is comprised of measurements made both on and off the Peeler's land. So his analysis as to the current state of the Peeler's reclaimed land is based on data that is at least 10 years old and includes measurements taken outside that land. It is simple logic that stale, decade-old data taken from sites that include areas outside of the Peeler's land cannot support conclusions about what is happening on the peeler's land currently. So the court cannot permit expert testimony that is not supported by a reliable basis in fact, and that's why opinion 2 should be excluded, Your Honor. Mr. McKinney's third opinion is that given the native soils and habitats of the area, including the native soils removed and replaced by the mining operation, the occurrence of saline soil conditions in the post-mine areas of permit 11G is expected. Like his first two opinions, this opinion is irrelevant as it has no bearing on whether San Miguel has met its contractual obligations with the mineral lease area. This opinion appears intended to persuade a juror to infer that the soil conditions on the Plea Ranch are naturally occurring rather than the result of San Miguel's intentional release of millions of gallons of polluted water or the result of decades-old seeps from San Miguel's former mine pits and retention ponds. But Mr. McKinney is not qualified to offer that opinion. He readily and repeatedly conceded that he is not a soil scientist and has no expertise in that field. Neither his education nor his training gives him any special expertise in soil chemistry, and he has not performed any soil testing at the Plea Ranch. To be permitted to offer any opinion, Mr. McKinney must possess special knowledge as to the very matter on which he proposes to give an opinion. Because he concedes that he is not a soil expert, he cannot be permitted to offer an opinion about the soil conditions on the Plea Ranch. Also, Mr. McKinney's opinion that the occurrence of soil saline habitat on the Plea Ranch is to be expected is based on his prior work generally mapping saline habitats which are associated with saline soil, and his review of a soil map he found in the mine permit files. But Mr. McKinney did not personally prepare the soil map. He also does not know who produced the soil map or how it was created, nor did he know whether any of the soil sampling performed to create the map was performed on the Plea Ranch itself. And he admitted that he's done nothing to confirm that the soil map he relies on is actually correct. He testified that, quote, "Not being a soil scientist, I wouldn't be involved in that kind of work." The only specific plant survey he conducted that forms the basis for his third opinion was a survey of black lace cactus, which he says is present in saline soils. But Mr. McKinney testified that he could not recall whether that survey identified any black lace cactus habitat on the Plea Ranch. He did not attempt to overlay the areas of purported saline habitats with the areas the peelers complain are contaminated to determine whether the two overlap in any way, and clarified that, quote, "I've not testified as to what's going on in the seep area." Mr. McKinney additionally purports to rely on years of mapping saline habitats in the general area of the Plea Ranch, but the court's prior holding limiting Mr. McKinney's testimony should preclude reliance on these unspecified surveys that were not disclosed by San Miguel or otherwise produced in discovery. In sum, Your Honor, Mr. McKinney offers an impermissible opinion on the law governing reclamation of the peeler's land and other opinions that lack any reliable basis. For these reasons, Mr. McKinney's testimony should be excluded and the court should grant the peeler's motion. Thank you.
And this is moving rapidly, which is excellent. I should have stated before we started, I need to shut this down not later than 3:10. All right, so Ms. Friel?
It's Louis Sutherland, Your Honor. I'll be speaking on behalf of San Miguel. Judge, Mr. McKinney, as Ms. Whittle explained, is a wildlife biologist. He has spent his career focused on habitat and vegetation reclamation assessments that are at the center of his opinion here. His opinions are squarely within the elements of his education and his experience. He's one of the most knowledgeable people in Texas about the reclamation and revegetation of surface mines. Just to give you sort of a roadmap of where I'm going to go in my presentation, just quickly on the first opinion that Ms. Whittle addressed that goes to the Railroad Commission requirements. She raised two issues. One was whether or not Mr. McKinney is testifying about the law, which he is not. He is not providing pure legal testimony. That's an argument that only came up in the appealer's reply. So it's not directly addressed in our response. I have some case law citations that I can provide to the court. If you need us to supplement the briefing at the end of the day today, I just ask that you ask us to do that so that we can give you those case citations, because that argument doesn't go anywhere. The second argument that she raised with respect to the first opinion was that his opinion with respect to the Railroad Commission requirements was irrelevant. That's kind of interesting because they raise those same statutory and regulatory requirements in their petition. And they also, their expert Gordon Johnson cited to these exact same rules in his discussion of whether or not the revegetation was adequate or not. With respect to the second opinion and whether or not Mr. McKinney's assessment of these revegetation as being productive pasture land is reliable, I think what you'll find after our presentation is Mr. McKinney relied on 53 studies conducted either wholly or partially on Peeler land using a Railroad Commission procedure that clearly meets the Robinson criteria for reliable expert testimony. And not only that, he relied on two other lines of evidence that Ms. Whittle did not address in her initial discussion with you, and that is he compared the production of those properties to average production within Atascosa and McMullen County for similar types of property. And he also conducted 2 individual inspections by himself where he went out there and looked at these properties contemporaneously with this lawsuit. And then finally, with respect to the third opinion, where Ms. Whittle says that he is not qualified to give an opinion with respect to these saline soils that are associated with thorn brush saline habitat. What's happening here is Ms. Whittle is arguing against the opinion she wishes Mr. McKinney was giving as opposed to the one he actually gave. He is an expert in the identification of habitat. This particular habitat is in all of the literature strongly associated with saline tolerant plants and saline soils. He's not rendering an opinion on soil chemistry. He's rendering an opinion that this habitat exists all around this area of Atascosa County. And that, of course, is relevant to the issue of, we've been talking about salt and soil, and probably every one of these hearings, that is relevant to where the salt came from if it's naturally occurring in these saline habitats. One of the things that is important.
Okay, and let me ask you to pause just for a minute.
Sure.
By that, you're saying that Mr. McKinney will testify that there are portions of the Peeler Ranch that have not been inundated with salt water from the mining operations that have plants growing on them that are indicative of saline soils?
Not exactly, Your Honor. A couple of things about that. One is, with respect to the mine lease property, there's not much land left that's in its native condition. So what Mr. McKinney is doing is going out and looking at undisturbed land and making a determination as to what that habitat is, whether it's, you know, some kind of just brushland, or whether it's one of this, it falls into this category of the thorn scrub saline habitat, which is fairly common throughout Atascosa County, especially southern Atascosa County. And so what the opinion that McKinney is offering is, I've been out there as part of a study that was conducted prior to this litigation. I have looked all around the Peeler Ranch, and I have identified the presence of this habitat in undisturbed areas, in areas that San Miguel may mine in the future. And he had to do that because the black lace cactus is an endangered species, and you have to identify those and deal with that as part of your mining plan. Now, with respect to the Peeler Ranch, you know, it was mined years ago. So we can't, nobody can go back and identify undisturbed native habitat within the mine area of the Peeler Ranch, because that's done. But what Mr. McKinney can say, and what he does say in his opinion, is this type of habitat is endemic throughout this area, and it would have existed in these Peeler Ranch areas prior to the time mining occurred. And when the topsoil was removed as part of that mining process, that naturally occurring saline soils would have been removed with it. Does that answer your question?
Yes.
Okay. One of the things about Mr. McKinney's testimony is he's not testifying about pollution. Almost everybody else, all of these other technical experts are testifying about pollution. He's really testifying about whether or not San Miguel has properly reclaimed these lands and revegetated them appropriately. Whether you're talking about the lease or the Railroad Commission requirements or anything else, that's the fundamental aspect of his testimony. And I don't think he's pretending to do anything else. I think, you know, we may get into sometime today that the aspects of Mr. McKinney's opinions that were properly disclosed. Obviously, we need to live within the confines of the order that the court has issued, but everything that I'm going to talk about today is in Mr. McKinney's report, or it was included in the materials that he produced as part of his file. All right, so jumping over to the first argument and getting into that in a little bit more detail, in terms of the relevance of the Railroad Commission standards, Tony, if you could pull up that number one, the Peeler's counterclaim petition, if you would please, and go to the breach of contract section in that petition. So this is the third amended counter petition that contains the Peeler's claims. We're looking at the breach of contract cause of action. We go to the next page and we look at paragraphs 2024 and 2026. Maybe we can blow that up just a little bit, Tony. The Peelers are asserting claims to restore the surface of their property and to replace the surface with the saved topsoil and to plant and sprig the perennial grasses selected by the Peelers within those reclaimed areas. That's part of their lawsuit, Judge, and that's exactly what Mr. McKinney is testifying about. And, you know, I'm going to come back to this paragraph 226, and I just want you to notice it where it says to plant and or sprig and establish perennial grass selected by the Peelers. That's important language. And I think as I go through my argument, you'll see that the understanding of the parties as to what that meant is informed by these Railroad Commission standards. All right, so let's jump down, Tony, to PDF page 74 in the Texas Natural Resources Code section of the petition. All right, so now we're in count number 5, Judge, the Texas Natural Resources Code section 85321. And if we can go to the next page, Tony, and then zero in on the highlighted paragraph. So the Peelers are asserting that they have been harmed by violation of the Railroad Commission requirements to complete reclamation efforts. As part of their counter petition is a separate claim that 16 Text Administrative Code 12383, those are the exact same Chapter 12 rules that Mr. McKinney is opining about, which are the Peelers, you know, assert a claim based upon the breach of those rules. And the idea that they're not relevant is just, I mean, I don't want to be flip about it, but it's silly. Okay, so let's, Tony, why don't we go, let's get Johnson's report that the plaintiff's expert, Gordon Johnson, Judge, is the one who talks about the inadequate reclamation or alleged inadequate reclamation of the previously mined lands. This is a copy of his report. And if we could go to PDF page 9, which is page 2-3, and then let's zero in on that highlighted section, Tony. Mr. Johnson says that according to in his opinion, the Surface Coal Mining and Reclamation Act, which is the statute that authorizes the regulations that Mr. McKinney is testifying about, and then similarly stated under 16 Text Administrative Code, Chapter 12, this is the same chapter that we looked at, slightly different section that was in the plaintiff's counter petition or the Peelers counter petition. And then he quotes those regulations to state the duty of San Miguel to restore the land affected to a condition capable of supporting the uses that it could support before mining. So their own expert is citing to these rules that they're now saying are irrelevant. Now, stepping back, the Railroad Commission standards are the accepted benchmarks in the state of Texas for revegetation success for surface mining. They've been that way for 20 years. They contain scientifically defensible measurements for the key criteria, the same criteria that Johnson, the peelers expert, looks at in terms of percent coverage, production, and grass species. I mean, those are the fundamental aspects of the regulatory requirements. They represent the accepted standards within the state. They include scientifically reliable methodologies for sample selection, statistical analysis to ensure that you're getting a reliable result. And then they include benchmarks to determine whether or not your revegetation, according to those criteria that I spoke about a few minutes ago, whether or not those are accepted. Importantly, the peelers, they point to the lease, but they hadn't pointed to any other standard. They haven't pointed to any other language. The language that they've included in their petition is very general and matches up with the same criteria that Johnson, we just looked at Johnson, that general purpose clause of the regulations, they're essentially the same. And importantly, I guess the big thing is the peelers hadn't pointed out where there's any differences. And so I guess I would say, Judge, the idea of relevance is whether or not it's helpful to the jury. I mean, clearly it would be helpful to the jury to look at these recognized standards within the state that have clear benchmarks, that have methodologies that are clearly reliable under Robinson, to look at them in the context of this dispute, even if the dispute is just limited to the lease. But we know it's not just limited to the lease because they've asserted a cause of action under the Texas Natural Resource Code. Just to go to what the understanding of the parties were, you know, if we are talking about the lease, Tony, if you could pull up the Peeler letter from 1992. So this is a letter, Judge, that Mr. Alonzo Peeler sent to San Miguel on December 4th of 1992. And Mr. Peeler told San Miguel, I wish to take this opportunity to request that my land, currently under lease to San Miguel Electric Cooperative at their San Miguel Lignite Mine, be reclaimed to pasture land rather than grazing land. That's a reference to two types of land uses under the Railroad Commission standards. You can reclaim to grazing land, which is what the original land was classified as prior to the mining, or pasture land is just a standard that emphasizes the production of grasses and improved grasses over a mixture of grasses and other more woody species. And Mr. Peeler goes on to state that he wants pasture land because that will give him better control over the various grass species that he would like to have replanted on his land. And that reflects back to the lease where we talked about a few minutes ago, where we said that, you know, the lease requirement is that San Miguel plant grasses that are acceptable to Mr. Peeler. In this letter, referencing these Railroad Commission criteria, or at least these Railroad Commission land use definitions, and we can go to the Railroad Commission definitions if there's any question about that. We can pop those up and I can show you that pasture land and grazing land are defined terms under the Railroad Commission rules, that represented the understanding of the parties. And so another reason why these Railroad Commission rules, not only relevant to Mr. McKinney, but relevant to Mr. Peeler too. So in summary, I mean, I think, you know, that both under the causes of action, under their the criteria that their own experts have identified as being relevant to these determinations, and under this letter from Mr. Peeler, this kind of testimony is clearly relevant. The other point that Ms. Whittle raised with respect to Mr. McKinney's testimony regarding the Railroad Commission requirements was that he was testifying again about the law. That's not really an apt description of what Mr. McKinney is testifying about. As the court knows, it's long been established that technical experts can testify about mixed questions of fact and law. I mean, that's not controversial. And the San Antonio Court of Appeals in Holden v. Weidenfeller made it clear that a technical expert can speak to what the requirements of a technical rule are and what the factual circumstances are related to compliance with that rule, which is in essence what Mr. McKinney is doing here. One particularly useful opinion is the Lyondell Petroleum Company versus Floor Daniel opinion out of the Texas Court of Appeals in Houston, 1st District. That's 888 Southwest 2nd, 547. The issue there was an expert who was testifying about safety. And he was testifying about what the OSHA safety rules were, what the relevant rules were, and what the technical requirements of those rules were, and indeed how the facts of the case related to those technical requirements. And in that case, the court said that that is perfectly acceptable expert testimony. And that's exactly what Mr. McKinney is doing here. And just to illustrate that quickly, Tony, if we could just pull up number 8, the McKinney report, and let's go to PDF page 12. So this is just Mr. McKinney's report. Here's opinion number 1, Judge, where he's talking about these rules. And if you'll kind of focus in on the bottom part of the page there, Tony, just blow the bottom part of it up. He's talking about the ground cover assessment, how that ground cover assessment is conducted, what the percent coverage requirements are. If we flip to the next page, and then sort of zero in on the top part there first, he talks about what the species composition requirements are, how you go about doing the statistical analysis to ensure that you're getting an adequate number of samples and a statistically significant result. Next section down, the sampling effort. I mean, the sampling effort is a random sampling technique that is relatively complicated to ensure that you're getting a representative sample across your entire study area. And then the next section down, I won't bore you with the whole thing, but there's similar kinds of discussion of the requirements under the Railroad Commission rules for herbaceous productivity. And so he's not talking about, this is not lawyer testimony, Judge. This is testimony about the technical requirements, the factual underpinnings of these relatively complex regulatory requirements. And clearly, it would aid the jury for somebody who's an expert in that to explain to them how this is done and what the meaning of the various results are. And so just to circle back just a little bit, if there is any concern about whether or not Mr. McKinney is testifying about the law, that's something that came up just in plaintiff's reply brief. If you want some additional briefing, or if you just want some legal citations to what I just talked about, we'd be happy to provide that in addition to what I just said. Switching to the second opinion, Your Honor, this is the opinion that goes to the issue of whether or not Mr. McKinney, the plaintiff's complaint is that his conclusion that based upon various lines of evidence is that the reclaimed lands of the peelers are productive. I mean, that's the essence of his opinion, is that they're highly productive. And that in general, that represents a successful reclamation. Ms. Whittle focused on one of the lines of evidence that he looked at, that is his study of the Railroad Commission reports that go to that issue. In addition to that line of evidence, though, he also, as I mentioned before, looked at the Atascosa County and McMullen County average production for similar lands and compared those, and determined that the peeler lands exceed those average production levels on a by an order of magnitude or more. The other thing that he did is he conducted 2 site inspections contemporaneous with his report, and in particular, in his second site inspection, went and looked at every single one of these revegetation areas that the peelers expert looked at, and spent just as much time looking at them as Mr. Johnson did. And so I guess the first point would be is that the RCT studies, while very scientifically robust and reliable, they're not the only line of evidence. He's got these other 2 lines of evidence too. I want to spend just a minute talking about the Railroad Commission methodology to show you how scientifically rigorous it is. So if Tony, if you could pull up number 4, that's the RCT revegetation standards. So this is a document by the Railroad Commission that Mr. McKinney used to, in his own work, to do these revegetation studies. And it's also the procedures and standards that apply to the studies that he's relying on as part of his opinion here. This is a 2014 version of that document. I know it goes back to at least 1999. I'm not certain if it goes back before then, but it's on the order of over 20 years old at this point in time. All right, so let's just go to the index. I won't spend a lot of time on this, Judge, but I do think that this is useful. If we could just zero in on the highlighted things there, Tony. So the Railroad Commission standards, they have detailed instructions on the methodology. This is revegetation success evaluation and measurement methods. And so they dictate the methodology for the selection of the number of observation points, typically for a land management unit, which is from 10 to 350 acres, you're sampling in at least 100 different locations. And then they go through and provide the methodology for how are you going to measure the ground cover percentage? I mean, how are you going to do that? And they specify methodologies that the Railroad Commission has independently concluded are reliable. And then they do the same thing for how are you going to measure the productivity? In this case, for the most part, what San Miguel did is they actually clip the grasses, dry them, and weigh them. And that's how they come up with annual productivity. And then the next section of these standards goes on to discuss how do you measure success? What is acceptable production for pasture lands? And you see the 2 classifications there that are referenced in Mr. Peeler's letter, grazing land and pasture land. And then let's jump to the next page, Tony. And I just want to point out here that they have a whole section on the various technical literature that's cited that underlies these standards. And there's 30 some odd citations to Texas A&M documents, other state documents on how to do these things, Department of Mining documents. And so these are substantially supported rigorous standards. All right, so if you go back and you think about Robinson and the criteria under Robinson for what reliable testimony is, and what we've got with this Railroad Commission methodology and measurement criteria, are the procedures to measure statistically significant? Well, yeah, we've got that piece of the requirement. Are they published? Yes, they've been published by the Railroad Commission for over 20 years. Is there a way to control for error? Yes. The statistical analysis that they do as part of this process controls for error. Is it a recognized methodology within the field? Yes, it's really the only recognized methodology in the state of Texas. Is there a non-judicial use? Well, yeah. I mean, it was created for non-judicial use to implement the Railroad Commission bond release criteria. So it checks all of those boxes. And so let's go now and look at Mr. McKinney's report and see how he looked at those Railroad Commission studies. So Tony, if you could just pull up table 2 of Mr. McKinney's report. And this is really small, Your Honor, but these are all the studies that Mr. McKinney looked at as part of reaching his opinion. And Ms. Whittle is right. Some of them are from several years ago, but there's a good reason for that. And as I'll explain in a few minutes, Judge, that actually makes the results more reliable, not less. And so if you look at this data, you see, for example, just looking at the top line, A1, the ground cover for the that was measured at San Miguel was 100% versus a ground cover standard of 70%. Same thing with the production estimate of 2.4, where the standard is 1.2. And if you just scroll through this table, every single one of these studies exceeds the standard. It doesn't matter whether it's on peeler land or whether it's on non-peeler land, or if it's on a land management unit that has both peeler land and non-peeler land. The answer is the same for every single one. They all show solid productivity, solid coverage. And so, you know, getting into an argument about whether or not one particular study shows is on peeler land or not really doesn't make a whole lot of difference, because the answer in each case is uniform. And that is that San Miguel has been highly successful wherever they have done this reclamation work at reclaiming to standards that far exceed the Railroad Commission standards. And that's what these studies show. I want to next address, Ms. Whittle said that Mr. McKinney looked at the San Miguel submittals to the Railroad Commission and coming up with this table. That's not true. He looked at the Railroad Commission approvals of the studies submitted to San Miguel. And it's worth a few minutes looking at one of those approvals. So Tony, if you wouldn't mind, let's pull up number 6. This was taken from Mr. McKinney's file, produced to the plaintiffs. This is one of the studies that he's relying on in connection with the table that we just looked at. This particular study involves land management units in Area A, Area B, and Area E. You'll see that there are multiple land management units involved, and for a total of close to 2,000 acres. And this is the Railroad Commission cover letter, and this is what the Railroad Commission said. This submittal includes vegetative cover and productivity data collected in 2004, blah, blah, blah. And then next, top of the next paragraph, the purpose of San Miguel's report is to demonstrate the vegetation parameters equaled or exceeded the approved success standards during the 2004 growing season. And then the determination by the Railroad Commission in the next paragraph, ground cover and productivity data have met the regulatory requirements. That's what the Railroad Commission said. All right, so let's go on to page 3. All right, so this is the technical memorandum by the Railroad Commission scientists. So if we blow up the top, you'll see it's by a woman, Liz Haney, a soil scientist with the Railroad Commission. And it's her review of San Miguel's study. And she sets out her purpose at the beginning of her report. The purpose of the submitted report is to demonstrate that vegetation parameters within the 4 ERAs equaled or exceeded the success standards during the 2004 season. And then she cites the regulation that mandates that pasture land vegetation parameters equal or exceed the approved standard during the growing season of any 2 years of the extended responsibility period, which is the period that happens after the basic revegetation work. So if you go on to page 5 now, Tony. In this paragraph, what we have is the TRC going through and verifying that the sample methodology, the sampling selection and the sample selection and the way that the samples were collected in the field meets their requirements. So it's not San Miguel's report sent to the agency. This is the agency review of that report saying, hey, you did it right. All right, so then go to page 6 at the top. We have, again, this is the agency saying that the productivity standards are standards that were developed by the Natural Resource Conservation Service, which the court probably knows is a part of the Department of Interior. So the criteria that San Miguel has to meet are criteria that are developed by the federal government. And dropping down to the bottom of that page. And then we get into the table. Judge, this is the same data that we just looked at in table 2. It just has it all compiled from all of these documents. There's several dozen of them that go into the 53 studies that are on the Peeler Ranch. And I didn't count the number that are not on the Peeler Ranch. But if you compare these numbers, then they will correspond to the numbers that were in the table in Mr. McKinney's report. So that's what Mr. McKinney did in terms of the assessment of the Railroad Commission studies. He used this well-recognized, reliable methodology where the methodology and the results of the testing were confirmed by the agency. Now let's talk about some of the Peeler's complaints, some of the things that Ms. Whittle brought up. First off, she talked about, well, she didn't like the way that Mr. McKinney did his averages across the various land management units. And the complaint, if you go back and you look at their motion was, well, he just averaged across all of the projects. So it's a project average. And Ms. Whittle says, well, you should have done it on a weighted acreage basis. You should have done, what's the productivity and the percentage coverage on a weighted acreage basis. Well, I mean, both of those numbers are potentially useful, Judge. I wouldn't say one is wrong and one is right. But the interesting thing is they didn't tell you what the data would be if you actually did a weighted average calculation. Well, I did it. It takes like 10 minutes. It's in, you can do it from the data from Mr. McKinney's report. And if you do a weighted average calculation, the numbers go up. So, you know, on a per project average, the coverage was 97.9. If you do a weighted average calculation, it's 98.8. And the production on a per project average is 3.1 tons per year. You do it on a weighted acreage basis, it's 3.6 tons a year. I don't know that those numbers are even significantly different, Judge. I mean, but the bottom line, Mr. McKinney's opinion is that these are highly productive pasture lands. And that's true whether it's 3.1 or 3.6. Another objection or complaint, I guess, that Ms. Whittle made about Mr. McKinney's use of these studies is that they're not sufficiently contemporaneous, that they're years old. And I want to address that point. But before I get to that, recall that these studies are not the only thing that he looked at. He also went out there and looked at the same points that their own expert, Gordon Johnson, looked at in a contemporaneous inspection. But be that as it may, even setting that aside, it's uncontested in this case that the San Miguel turned these properties over to the peelers for their use after these vegetation assessments during the final stages of the bond release process. Once they turn these properties over to the peelers, they're subject to vegetative degradation for reasons that have nothing to do with San Miguel's work to revegetate the property. The best evidence of San Miguel's efforts to revegetate the property are before you have any other conflicting reasons why we may be seeing damage to vegetation. And there's clear evidence of damage to vegetation, primarily by the peeler's cattle grazing. So if we go to Mr. McKinney's report, and this is in his report, if you go to Mr. McKinney's report, let's go to page 42 of the PDF. So this is a watering trough that was installed in one of the areas where Mr. Johnson took his sample and said that it's poor vegetation because of San Miguel's failure to properly revegetate it. I mean, it doesn't take a cattle ranching expert to see that, there's been a lot of loss of vegetation in the vicinity of that watering hole. And we could go to the page, I guess it's page 40. So this is the same area, Judge, and it's a little hard to see here. I wanted to have both pictures on there, but if you look, the top picture is before the watering hole is there, and then the bottom picture is after it's there. And you can see the degradation that has occurred because of the use of that watering trough by cattle. And it's not just Mr. McKinney. If we go to number 9, the OSM inspection report, Tony, this is an inspection that was conducted by the United States Department of Interior of that same area. This is the B7 Land Management Unit on the Peeler Ranch. It was conducted in April of 2019. And the bottom line of this inspection is that they didn't see problems with the soil. They saw problems with cattle ranching overgrazing. So if we just quickly, I don't want to spend a ton of time on this, but if you go down to page 4, zero in on that highlighted section. Land is currently grazed, so it was grazed. Page 5, pictures of cows. That's that same watering hole right there. And then bottom of then page 6 there at the top. Let's just focus in on that top section. You can see based on the language of the OSM inspectors that what they saw here was overgrazing from cows. And so that's why it makes a whole lot more sense to do the inspections and look at the inspections that Mr. McKinney did before that kind of adverse action takes place. And it's not just cows. I mean, we can go back, and I'm not going to spend the time because I know we're a little bit on the clock here, Judge, but we can go back and look at his report, and there's similar photographs and discussion from Mr. McKinney's report about impacts that happened after the studies that occurred because of oil and gas activities, developing pad sites for oil and gas activities and pits for oil and gas activities. You can go to the report, you can see the pictures. Same thing is true with respect to pipeline construction and pipeline maintenance. You can see the pictures where the ground has been disturbed as a result of those activities after these studies were done. Very quickly on the last thing that Ms. Whittle said with respect to the reliability of these studies is she talked about the potential for pollution and that occurring in between when the studies were occurred and when Mr. McKinney rendered his opinion. Mr. McKinney's not rendering an opinion about pollution. He's not going to testify at trial about pollution. He carved out the seat areas, as Mr. McKinney said, as Ms. Whittle said, and because that's an area where we do have issues. But the area that we're talking about in terms of the success of revegetation, their own expert, Gordon Johnson, said it's area B. And if we look at, I'm sorry?
He said it's what?
Area B. That's
Okay,
one
I'm
of the
sorry.
areas, it's one of the areas at the mine. And let's just jump to the second picture of area B. That's number 11, Tony. So the area up there in yellow, that's area B, Judge. This is a figure from Gordon Johnson. That is the Peeler's report. The colors, if you recall, that's the electrical conductivity. Blue is the lowest electrical conductivity. So there's no elevated electrical conductivity in area B. And all of the sample results are all those little dots with the numbers around them. There's not a single sample result up in area B that suggests there's any pollution. So this whole idea of, well, I didn't consider pollution, that's a complete red herring, Judge, because McKinney and Johnson are focused on area B, and area B is outside of the area that even the peelers say has experienced some sort of spill. All right, and then the last thing in terms of Mr. McKinney's opinions that Ms. Whittle raised was this idea that he couldn't render an opinion on the presence of saline thorn scrub habitat. And that's the core area of his expertise, is the identification of habitat. And the confusion here is he's not rendering an opinion on soil science. And what he did is the study that he conducted with respect to this habitat, he didn't even do that for this litigation. That study predates this litigation. So it's a non-litigation study. It was done for mine permit compliance for the endangered species of the black lace cactus. It was done in April of 2018. And as I discussed at the beginning, and I won't repeat it, you know, we can't do that kind of study in the Peeler Ranch area anymore because there's not that much undisturbed habitat left within the areas that have been mined and are covered by the mine lease. But that habitat does exist all around the Peeler Ranch. And when Mr. McKinney went and looked for this habitat, he found it all over the place, which isn't all that surprising. So, you know, just why don't we go to the Texas Parks and Wildlife Habitat document. It's in the Black Lace Cactus Study. That's number 13, Tony. And let's just go to page 29. So this is Mr. McKinney's study. And you can see that this is the Texas Parks and Wildlife document that identifies the locations of this saline thorn scrub habitat. It's common in the southern Atascosa County. This study includes a map which shows the numerous locations where Mr. McKinney found that habitat. And if you just go to I think it's the next page, Tony, where they describe the habitat, or maybe the one above it. No, go up. Yeah, here. So just zero in on this. I mean, Mr. McKinney's not rendering a soil chemistry opinion. The soil chemistry comes from the definition of the habitat by the Texas Parks and Wildlife. I mean, this habitat exists where there are saline soils. And so that doesn't take McKinney to get there. McKinney is just saying that this habitat exists, and it exists pervasively around the Peeler Ranch. And finally, the final point I want to raise on that is that Mr. Whittle talked about Mr. McKinney's use of the soil survey map in this study. That's really, it doesn't have anything to do with his conclusions. What Mr. McKinney used the soil survey map for was to geographically identify areas where he would then go out and walk the property to see if the habitat existed. So, you know, that doesn't go to the conclusions of his opinion. It's the beginning step of where do I go look for this? And that's not a basis for saying that his opinion is unreliable. I'll stop there. If you have any questions, I'll be glad to answer them, Judge.
Not right now. Very briefly, Ms. Will, and then you can start off the Dr.
Your Honor, I have just one comment on behalf.
I'm sorry.
No, of course. And the quick comment is it's with respect to the relevancy of these reclamation and remediation items. During both the motion to exclude and also during the argument on the peelers, it was noted that these opinions aren't relevant because the Peeler's claim relates to San Miguel's breach of the mining lease and the restoration requirements under the mining lease. As this court is very aware, Kiewit Mining Group is not a party to the mining lease. So any type of obligation for restoration of the land under the mining lease, it doesn't affect Kiewit Mining Group. So Mr. McKinney's opinions with respect to the benchmark created by the Railroad Commission on what's required for restoration and reclamation will be relevant to the Peeler's claims to the extent there are any for Kiewit Mining Group and property outside of the mining lease that needs to be restored and reclaimed, which is part of their mandatory injunctive relief request to the court. So those opinions by Mr. McKinney are relevant to the Peeler's claims as with respect to areas outside of the mining lease and claims against those against Kiewit Mining Group in the situation, Your Honor. So they are relevant to the claims in this case.
So, Your Honor, Mr. McKinney doesn't opine on anything outside of the mine lease permit boundary, the mine permit boundary, which is completely subsumed by the lease premises boundary. And what's clear from Mr. Sutherland's presentation is that San Miguel fully intends to go down the rabbit hole of permit conditions and reclamation regulations. San Miguel sought, and this court granted a motion dismissing all of the Peeler's tort claims within the lease premises. So the contract language controls, and the contract predates and does not incorporate any of these reclamation standards. And Mr. McKinney clearly testified that he is not opining on lease provisions and has never reviewed them. Mr. Johnson's report regarding reclamation standards was disclosed prior to this court's ruling on the economic loss rule. So his report includes opinions to support our now dismissed tort claims within the lease premises. Those standards regarding productivity of grasses have no relevance to any harm outside of the lease boundary. The productivity of grasses in the formerly mined area is limited to the boundary of the lease premises. So the fact that those reclamation standards are referenced in Mr. Johnson's report does not render Mr. McKinney's opinions regarding reclamation standards for ground cover productivity relevant to the breach of contract cause of action, which is all that remains in the lease premises. With respect to his testimony regarding saline habitats, Mr. McKinney clearly testified that he cannot say one way or another whether he has identified any of those habitats on the Peeler Ranch. And Mr. Sutherland admitted to this court, those surveys were all around the Peeler Ranch, meaning off-site. And the ranch is 25,000 acres large. And I'd like to show, Your Honor, the actual survey from that black lace cactus survey. Hold on one second and I will share my screen. Your Honor, Mr. Sutherland testified inaccurately that this black lace cactus habitat that Mr. McKinney relies on is all over the place, surrounds the Peeler Ranch. But as you can see, this is his actual survey. This is the cactus population in 2018.
Okay, I see nothing of the sort. I see a map with some gray, green.
Can you see this red area, Your Honor? Here, I'll make it larger.
I see a red dot.
Yes, that's the cactus population, Your Honor. So this is the legend. It shows the cactus population. There are, I believe, 4 population units, one here, one here, one here, and then all the way up here, 4 and 5. And all 5 of those are off the Peeler Ranch. None of those are actually located on the Peeler Ranch or anywhere in dispute. So Mr. McKinney testified he hasn't compared those locations of habitat to the areas in question, but I just did that with Your Honor. They're completely off-site of the Peeler Ranch. He also testified that the black lace cactus was identified in the permit area only recently, meaning in the last 2 or 3 years. So it wasn't even present prior to mining, which of course supports our argument that San Miguel's operations have increased salinity in the soil and groundwater through mismanagement. It's certainly not proof that the Peeler Ranch has been restored to its original state and question, which is the question before the jury. Mr. Sutherland showed you our breach of contract language regarding the planting of approved grasses. Mr. McKinney's opinion does not relate to that provision because he clearly testified that his productivity numbers includes non-approved invasive grasses that have established on the Peeler Ranch in the former mine area, including King Ranch bluestem. You may recall the 1992 approved grasses letter that Mr. Sutherland showed you. Mr. Peeler in that letter identified certain approved grasses. He did not approve KR bluestem, which is a low value grass not appropriate for cattle. But Mr. McKinney did include KR bluestem in his productivity ground cover numbers. And I'd like to show you Mr. McKinney's testimony on that point.
All right.
Your Honor, here I ask him, so attachment C, where those landowner consultation letters are, also included a letter where Alonzo Peeler approves certain grasses for post-mine planting, and attachment D includes the Railroad Commission approved grasses for San Miguel Mine. Is King Ranch bluestem an approved Peeler or Railroad Commission grass? Not that I'm aware of, no. Have you observed KR bluestem on the Peeler Ranch? Yes. So you described KR bluestem as an invasive species. Is it a good pastureland species for cattle? It is a low quality pastureland species. Then I asked him, so just to be clear, for your 2012 productivity report for Land Management Unit BX4, did you include King Ranch bluestem, a non-permit species, in your clip plot because you considered them forage? And he says, if KR bluestem was part of the clip plot and forage, it would be included, yes. So even if it's a low quality species like KR bluestem, you include it as equivalent to any other grass in the clip plot. And he said, I include it as part of the sample, which would show what the production of that particular spot or location would be. So his opinion on productivity for ground cover under the reclamation rules is not relevant to whether San Miguel has met the requirement for establishing approved grasses under the lease. Because it is irrelevant, it would serve only to confuse the jury and waste time. Mr. Sutherland is incorrect that the property has been turned over to the Peelers. As this court knows, San Miguel asserts ongoing possession of the ranch under the lease, and in fact is arguing that it must condemn nearly 7,000 acres of the ranch in order to provide electricity to its customer STEC. So the court should dismiss that argument entirely. If San Miguel believes it has met its restoration obligations, then it should turn the ranch over to the Peelers and leave the premises. In any event, Mr. Sutherland has done nothing to show how Mr. McKinney's opinions are relevant, nor has he demonstrated that Mr. McKinney's opinions are based on a reliable foundation. So we ask that this court grant our motion and exclude Mr. McKinney.
Judge, can I have like 2 minutes?
Let me ask. So is the mining lease exclusive, or are the Peelers still have still run cattle on the ground that's, for instance, it's being reclaimed or which has not yet been mined?
The Peelers have had to remove all of their cattle because of the contamination, but there was a period of time where there would be cattle on the property in certain areas.
My understanding, Judge, is prior to this lawsuit, the Peelers regularly ran their cattle on virtually all of the land that was in the extended response period.
And in fact, they didn't remove the cattle until after, about 6 months after this lawsuit was filed.
Your Honor, the permit allows cattle to be grazed on the property. It's included in part of the permit conditions, and other landowners also do the same thing. There's nothing untoward about that.
And to be clear, we're not saying it's untoward, it's just adversely impacting the quality of the grass.
in. Are the peelers alleging that the KR blue stem was seeded or sprigged rather?
No, Your Honor, the argument is that San Miguel did not place appropriate topsoil specifically in the area B. And so the grasses that were planted didn't establish, and KR blue stem, which is an invasive grass that like Texas Highway Department sprays everywhere and is kind of in the air, took over that area because there wasn't appropriate topsoil placed.
Okay.
That was one of the points I wanted to bring up, Judge, and my short rejoinder was KR Bluestem was not brought up in the peeler's motion. The most likely way that KR Bluestem gets onto this ranch is from the farm equipment and the cattle that come from the peelers, because there's KRB on the rest of the peeler ranch. It's another reason why that the use of this property by the peelers degrades the property over time.
Your Honor, Mr. McKinney's opinion does not at all suggest that the peeler's use of the property has degraded it. In fact, he states that the peelers have engaged in appropriate land management techniques. So this whole sideshow that Mr. Sutherland has brought up has nothing to do with Mr. McKinney's opinions or whether or not he should be excluded.
I just direct the court to Mr. McKinney's report and the 5 or 6 pages of photographs of the cattle around one of Mr. Johnson's opinions, and I'll stand on what the report says.
Okay, is there sufficient time to do justice to Mr. Motion to exclude Dr. Verslicki?
I've forgotten what time you need to leave, Your Honor.
3:10.
Probably not. I can start, but I don't know that I don't know how long Ms. Peloso's presentation is.
Mary, I can condense to probably 15 to 20 minutes, depending on obviously what you raise. So up to you. I don't know how long you think you'll need.
All right, well, let's go ahead and get started to do what we can.
Okay, Your Honor. Dr. Timothy Verslicki is San Miguel's designated expert in the field of ecological risk assessment. Ecological risk assessment is the evaluation of probability of harm to a receptor, like a songbird or a salamander, from a stressor, like a chemical. Regulatory agencies like EPA use ecological risk assessment to determine whether to approve proposed actions, like the registration of a pesticide. They also use them in developing rules. For example, EPA conducted an ecological risk assessment to assist the agency in developing the coal ash rule. Where an agency is using an ecological risk assessment to set thresholds for unacceptable risk of harm, inherent in that is an acceptance that some receptors, like songbirds or salamanders, will die from the stressor, and some will suffer non-lethal toxic effects, such as disrupting their reproductive system. This is a very specific, esoteric analysis of probability that has no place in this case. First, a private landowner such as the Peelers does not have to agree to such risk on his or her own land. But also, the Peelers are not arguing in this case that coal ash contamination on their property presents an unacceptable risk of harm to songbirds or salamanders or any other wildlife receptor. Instead, the Peelers claim their real property, their land and water, has been harmed by San Miguel's breach of its lease contracts and negligence. San Miguel has introduced unlawful pollution to the ranch, and the fair market value of their property has been diminished by San Miguel's operations at the power plant and the mine, including turning the ranch into a permanent solid waste disposal site. This isn't a theoretical matter of probability. The soil on the ranch has disaggregated or fallen apart from the salts that have been discharged to the land and seeped through the ground via mismanaged wastewater and polluted groundwater. As a result, the grasses have died. If salt pollution is not addressed, the ground will erode back to the bedrock. Property suffering from salt pollution often looks bombed out or like a crater on the moon. And that's not to mention the other pollutants, like the heavy metals associated with coal ash that have been introduced to the ranch by San Miguel's operations. Dr. Verslicki holds a PhD in applied biological sciences from Ghent University in Belgium. He's a principal at a consulting firm called Gradient. His report offers 5 opinions that reduce to the criticism that the Peeler experts did not conduct an ecological risk assessment. The Peelers ask that Dr. Verschlicki be excluded for a number of reasons. First, he's not qualified as an expert in this matter because his expertise concern ecological risk assessments in the limited context of risk-based cleanup managed by a regulatory agency, which is not at issue in this case, and he has no expertise in any relevant field. He does not know what regulations actually apply to the Peeler Ranch site. He has no experience addressing coal ash contamination of soil or groundwater, nor has he even reviewed the ecological risk assessment for coal ash disposal conducted by the EPA, which the federal government used when setting the regulatory standards for all coal ash disposal sites, including the San Miguel power plant. Dr. Verschlicki's premise is that the only way to examine the environmental effects of contamination is by using the tool he knows best, and it squarely contradicts the consensus of San Miguel's other designated experts. It reveals that Dr. Verschlicki's myopic perspective. He's an expert with a hammer, and so the whole world looks like a nail. San Miguel experts Mark Hemingway, Bill Meister, and Dr. Peter Peme all testified they have never performed the assessment Dr. Verschlicki demands, and yet they have all been able to delineate waste contamination or design remedial plans, or both, over the course of their careers and in this case. That testimony is attached as exhibits to our motion. The Peelers do not dispute that Dr. Verschlicki is qualified to perform ecological risk assessments. They just have no application here. Dr. Verschlicki admits that he has no experience in cases outside the narrow context of cleanup performed under the purview of a regulatory agency. He expressly testified that his expertise does not apply to the material issues the jury must decide in this case. A risk assessor is not looking at whether waste contamination is present at a site or whether waste contamination has been completely delineated. Instead, his goal is to, quote, evaluate risks and inform a risk-based remediation under a regulatory program, which in contrast is not at issue here at all. Again, all of that testimony is attached to our briefing. Texas courts have held that a purported expert must possess special knowledge as to the very matter on which he proposes to give an opinion. Dr. Verschlicki's testimony makes clear that he is not an expert in how to identify and delineate contamination, which is the matter upon which he opines. To demonstrate that Dr. Verschlicki is qualified to assess the methodology in selecting background levels to identify the presence and contamination on the Peeler Ranch, San Miguel argues that an essential part of any risk assessor's skill set is the evaluation of background data sets and comparison of available data to the selected screening levels, be they background or values established by regulatory agencies. But Dr. Verschlicki's experience is in examining the appropriate background level in the context of risk assessments. That does not lend him the necessary experience to opine regarding how to detect the presence and extent of contamination or the appropriate remediation of a ranch back to usable pasture land, which are the relevant issues in this case. Ecological risk assessments simply do not simply detect contamination and injury to real property. Instead, they layer on the additional factor of whether the risks a certain stressor poses to wildlife receptors exceeds levels deemed acceptable by regulators. So the selection of background levels and their application to the analysis Dr. Verschlicki is qualified to perform involves different considerations and a different set of skills than those at issue in this case. I'd like to show Your Honor a little bit of his testimony on this.
Go ahead.
Hold on one second. Okay, Your Honor, in explaining, what risk assessments are, he said, in ecological risk, there are not necessarily regulatory thresholds that would make that distinction between what is acceptable versus non-acceptable, with maybe few exceptions. So it's really a side-by-side evaluation that relies on the risk assessor and ultimately the risk manager, the overseeing agency, to determine whether, so as the risk assessor, I calculate the probability that there may be an effect, and then it's up to the agency that's overseeing the risk assessment to decide whether that risk needs management. And again, that would depend on the site, the states, the regulatory framework, the risk assessments being conducted under. And then he explains, risk is a probability, right? So it's not a discrete thing. He explains that just like cancer risks in human, health risk assessments are estimated as a, 1 in a million or 1 in 100,000. So it's an estimate of probability that something occurs. It's probability. And the greater the numbers, the greater the likelihood of an adverse effect. So the coal companies argue that Dr. Verslicki's lack of qualifications actually goes to the relevance of his testimony. But by way of analogy, while the opinions of an expert in LASIK eye surgery are irrelevant to a case concerning a broken foot, she would also be unqualified to opine as an expert on orthopedic issues. So while it is true that Dr. Verslicki's opinions are also irrelevant, the issue regarding his qualifications is that they apply to a different field that is not at issue here. And such ancillary qualifications are inadequate to establish him as an expert in detecting and delineating contamination. In fact, the second reason the appealers asked the court to exclude Dr. Verslicki is that his testimony is irrelevant. He confirmed that he offers no opinions on the material questions of whether San Miguel's operations have resulted in waste contamination on the Plea Ranch, the delineation of that contamination, or the appropriate remedy. And I'll share just a little more testimony, Your Honor. When I asked him if it was his opinion that there was no waste contamination at the Plea Ranch, he said he hasn't rendered an opinion one way or the other of whether there's waste contamination. When I asked him if he was going to offer any opinions on remedies, he said he did not think so. So Dr. Verslicki insists that the Peeler experts employed a flawed methodology because they did not perform an ecological risk assessment. But nothing in this case asked the jury to assess the ecological risk of contaminants on the Peeler Ranch. Instead, the Peeler's claims turn on the presence and extent of contamination and whether that contamination has harmed the property or reduced its fair market value. Whether such contamination risks causing an impact to a designated receptor species, such as songbirds or reptiles, at a level deemed unacceptable by a regulatory agency, has absolutely no bearing on any claim or defense in this case. His testimony leaves no doubt that in his opinion, even the direct observation of dead plants in the area of known pollution release means nothing, absent the application of his favorite analytical tool. And all of the other experts identified by San Miguel, and even San Miguel's corporate representative, testified to the opposite of Dr. Verslicki. Astonishingly, in its response, San Miguel argues that Dr. Verslicki's opinions do not demand an ecological risk assessment, but that's exactly what his sworn testimony and his disclosed report both state in no uncertain terms. And I'll show those to Your Honor. So here, Your Honor, I asked him, so if you have deceased vegetation in the area of a release, the only way you'll know that the release caused the deceased vegetation is to conduct an ecological risk assessment. He testified, right. And I said, so why wouldn't that be true with the Exxon Valdez? If you have a bird covered in oil in the area of the release, wouldn't you also need to conduct an ecological risk assessment to know that the oil released caused the death? And he testified, well, my opinion as it relates to this site is that there's an allegation made that the vegetation in the related ecosystems are impacted by seeps and soil and groundwater. And what I'm opining here is that to evaluate whether that is indeed the case involves the scientific evaluation called a risk assessment. So he is absolutely opining that the peeler experts should have conducted a risk assessment. And here from his report, his first opinion states plaintiff's experts did not conduct an ecological risk assessment to evaluate the ecological significance of the background exceedances they describe and to support their opinions regarding alleged environmental impacts and the need for remediation. So there's no question that his opinion is that they should have conducted an ecological risk assessment, even though none of San Miguel's experts did that. The peelers' tort and contract rights to have their land remain free from contamination are entirely divorced from regulatory determinations of acceptable probabilities of harm. Further, they have nothing to do with any probability of injury to a designated receptor species. So ecological risk has no relevance to this lawsuit. The third reason the peelers ask the court to exclude Dr. Verslicki is that his methodology is unreliable. He applies a double standard. Dr. Verslicki insists that the peelers experts should have conducted an ecological risk assessment, yet he excuses San Miguel's experts for the identical omission. He rationalizes this double standard by speculating that San Miguel's experts probably, quote, get to the same place without using his preferred technique. Why that isn't true for the peelers experts who use the exact methodology as San Miguel's experts he is totally okay with, he could never explain. The peelers and San Miguel's environmental experts applied the same general investigatory method and chose the same restoration technologies. The only substantive difference between them is their opinions about the size of the area that needs to be addressed. Dr. Verslicki admits he has not even reviewed what the San Miguel experts did to investigate the site or develop their proposals, and therefore he cannot provide any probative testimony regarding how San Miguel's experts' analysis is different or better than what the peelers did. So his opinions are nothing more than unfounded speculation. And just to illustrate the incoherence of his analytical methodology, he argues that the peelers must conduct an ecological risk assessment to determine what he calls ecological significance before they can establish the existence of waste contamination or design a restoration plan. But when I asked him 5 separate times, what is his definition of ecological significance, he could never provide any definition or explanation of what it means. So it begs the question, what's the point of conducting an analysis to determine ecological significance if he can't even tell us what that means? Again, that testimony is attached to our motion, Your Honor. In fact, Dr. Verslicki is unable to articulate what triggers the need for an ecological risk assessment, what an ecological risk assessment actually comprises, what the goal of an ecological risk assessment might be, or when one might be concluded. He couldn't even say for certain whether he has conducted an ecological risk assessment in this case. And this testimony was sort of astonishing, Your Honor. I'd like to share it with you.
You don't have to ask for permission, anyone, just go ahead.
Okay, well. So here he testified, as I said, I have conducted risk assessment evaluations as part of my report. And then just a few moments later, I said, did you do an affirmative risk assessment to replace what you thought was inappropriate for theirs? I have not. Each of Dr. Verslicki's specific opinions is unreliable. His first opinion that exceedance of background values alone does not establish widespread ecological harms is inadmissible because it attacks a straw man. No one in this case purports to establish, quote, widespread ecological harms, nor does anyone attempt to establish waste contamination based on the exceedance of background values alone. Instead, the peeler experts are clear that they considered multiple lines of evidence in reaching their conclusions. We've attached as Exhibit 2 to our reply testimony from Anthony Brown explaining that exceedance over background is not the only indication of contamination that we considered. He testified that he considered the geophysical results, visual observations of soil surface and vegetation, and historical operational records from the plant and the mine indicating incidences of discharge or release of contaminants. In his deposition, even Dr. Verschlicki admitted that peeler expert Gordon Johnson relied on additional lines of evidence other than comparison to background to delineate the smaller area of remediation. But Dr. Verschlicki just didn't understand the details of how they were considered. His confusion does not mean those lines of evidence somehow cease to exist. Because the peeler experts expressly are not performing comparisons to background values alone, his first opinion is not grounded in the facts of this case and is therefore not admissible. His second opinion that the soil background locations selected by the peeler experts are biased towards areas of lower soil salinity and do not represent the full range on background levels at the ranch is also unreliable. It relies exclusively on the USDA soil salinity map, which experts for all parties agree is unreliable. It is based on only 4 samples taken somewhere in Atascosa County and none on the Peeler Ranch. Second, in reaching his definitive conclusion that the peeler expert's sampling of background salinity is biased, he did not even consider the historical pre-mining soil conductivity data taken on the Peeler Ranch itself, which is documented in the record of this case. His failure to consider that relevant evidence while relying entirely on an unreliable source renders his conclusion unreliable. Third, the analytical gap between the evidence and his conclusion of bias in the peeler expert's background sampling is huge because he relies on unfounded assumptions and arbitrary decisions and fails to apply any sort of statistical analysis before reaching a conclusion about numerical significance. What he does is he claims to have plotted the information from the unreliable USDA map, and then he drew an area to delineate what he called background, apparently relying on no objective criteria to set those boundaries. He then estimated through some unknown process the acreage within the arbitrary area reflecting salinities over 2,000 millisiemens, as shown on the unreliable USDA map, to arrive at an approximate percentage value of 44% background territory with salinities over this threshold. He then rounds this number up to describe it as almost half and declares without any statistical or any other type of analysis that this reveals that the peeler sampling is skewed and not representative. Even were this based on reliable information, his purported methodology involves numerous unjustified assumptions and arbitrary decisions and no statistical analysis. It is anything but scientific and definitely is not something an ecological risk assessor normally does as part of his work. His made-up method based on unreliable information leaves an enormous analytical gap. And as Dr. Ross explains in her rebuttal report to Dr. Verschlicki, the fact that the USDA map, which she used to help locate her samples in different soil types, turned out to be incorrect and unreliable, doesn't reflect a bias in her choice of sampling locations. It just means the best available information wasn't as helpful as she had hoped. His opinion number 3, the Alberta soil guidelines used by the peeler experts are not appropriate because they are below the soil salinity levels at many background locations on the Peeler Ranch, misunderstands both the peeler experts' use of the criticized reference values as well as the meaning of the soil salinity values at background locations. He insists that the Alberta Tier 1 criteria used by Gordon Johnson are inapplicable regulatory standards. But Mr. Johnson's testimony makes clear that he is not employing the Alberta guidelines as a background indicative of the natural conditions in Texas, nor does anyone suggest that Canadian regulations apply in Texas. But instead, the Alberta guidelines are applied as a published standard to establish a threshold level for the onset of harm to the types of vegetation that were found on the Peeler Ranch before it was contaminated. San Miguel's expert, Mr. Hemingway, also uses a non-Texas published standard for his remedial program for the soils in the buffer zone. In any case, Dr. Verslicki's third opinion also ignores that Mr. Johnson used the published Alberta guidelines in conjunction with published criteria from Texas A&M to establish the threshold for the harm he selected. He also evaluated the background samples from Dr. Ross's program and historical soil monitoring data from San Miguel's permit filings in designing his remedial program. So Dr. Verslicki's attack on the Alberta guidelines fails to recognize that they were employed specifically to address salt tolerance of the relevant vegetation and correlated with Texas-specific publications along with site-specific information about soil quality. So his third opinion demonstrates that he doesn't understand or the intent or application of the value he criticizes, and so it should be excluded as unreliable. His opinion number 4, that the peeler's calculated soil background concentrations for several metals are below statewide screening values established by the TCEQ, has no relevance in this case. Contamination levels that regulators deem relevant for certain governmental programs do not address any material question in this lawsuit. This case concerns whether contamination violates the peeler's private rights to be free from injury to their property as defined under tort and contract law. San Miguel's emphasis on statewide screening values amounts to a proposal that a polluter is categorically free of liability to a private landowner for any contamination that falls short of regulatory thresholds. Were it actually the law, this rule would impose an extraordinary novel limitation on the right of private parties to contract freely, and it would define tort law, including adding an entirely new material element to the law of trespass. Their revolutionary new legal theory has no support in Texas law. Indeed, regulatory statewide screening levels developed for a government-based, risk-based program have no bearing on whether the peeler's private property rights have been violated. And an expert injecting such values into this lawsuit are nothing but a distraction calculated to waste time and confuse the jury. So it should be excluded. Also, Dr. Verslicki admitted at his deposition that the Texas rules for the metals he is concerned about, in his opinion, require an analysis of bioaccumulation, meaning the TERP screening levels he's relying on are not applicable here at all. So his opinion is a complete distraction. And that testimony, Your Honor, is here. I asked him, and in that table, it lists cadmium, chromium, lead, mercury. Let's see, what is the other metal that you said was below the benchmark? I believe it lists 5 of the 6 metals that you describe as being innocuous, that are at levels that are innocuous. And given that these are bioaccumulative, is it really fair to say that if the background level is lower than the benchmark, that these metals are innocuous? And he said, I don't disagree that you would obviously have to go through the different steps of the process. I'm clearly not stating that bioaccumulation is not an important factor. To be absolutely clear, Your Honor, there is no regulatory body mandating any cleanup on the Peeler Ranch. San Miguel has entered the buffer zone acreage, a mere fraction of the contaminated area, into TCEQ's voluntary cleanup program under TERP. But no ecological risk assessment was performed as part of that effort. In fact, the minimal voluntary effort performed by San Miguel, which we think is wholly ineffective and insufficient, does not rely on any TERP regulatory standards. San Miguel is implementing this voluntary cleanup based on visual observation of salt impacted soils, the geophysical study conducted by Advisian, and published standards for electroconductivity in soils not specific to Texas. So even if the voluntary effort that San Miguel is implementing to restore the stores and soils in the buffer zone had any relevance, it actually undermines Dr. Verslicki's critique of the Peeler experts' methodology, because San Miguel is implementing it without an ecological risk assessment. His opinion number 5, that by relying on overly conservative background values, the Peeler experts have overestimated the size of the impact on the Peeler Ranch, is entirely dependent on his prior conclusions. Because those conclusions are themselves unreliable and unfounded, this fifth opinion is inadmissible. And San Miguel misrepresents the Peeler experts' analyses by claiming that the Peeler experts automatically attribute every dead plant to San Miguel. The Peeler experts conducted a robust site investigation using several investigative technologies that together support their reasonable and conservative estimates of the cause and extent of the waste contamination and the reasonable and necessary remedial actions to restore the ranch to usable pasture land. In fact, the Peeler experts were clear that they did consider whether other sources might have caused or contributed to the observed contamination. But as Anthony Brown testified, he could not identify any potential alternate source consistent with the magnitude, location, and extent of contamination observed. Lastly, the Peelers asked the court to exclude Dr. Verslicki's testimony because it would be unduly prejudicial, because lay jurors would be led to believe that he is an expert on an important issue, when in fact he lacks the requisite expertise, and furthermore, his opinions are unreliable and irrelevant. That's all, Your Honor.
All right, Ms. Peloso?
Yes, Your Honor. I'll get started and I'll do my best to wrap up on time. Your Honor, I think first of all, I want to be clear about what Dr. Verslicka is opining on. His opinions here really go to the methods used by the Peelers. He is not giving his own opinions on the nature and extent of contamination. And one thing I do want to underscore at the beginning here is that contamination is a fact issue in this case. The Peelers ask the jury and you to accept that anytime you find a measurement that they say is above what the background conditions would be, and I'll speak more about background in a minute, that qualifies as contaminated. Dr. Verslicka is offering an alternate view of how the established techniques of ecological risk assessment, which is a well-established science that is frequently used outside of a litigation context, might define contamination. Again, he is not himself offering independent opinions about the nature and extent of contamination, but more providing tools to help the jurors assess the factual question of whether the Peelers have proved their allegation of widespread contamination across the ranch resulting from San Miguel's activities. San Miguel offers Verslicka as an expert witness to respond to allegations made by the Peelers and their experts that operations resulted in widespread contamination and environmental damage of the ranch. He is directly rebutting the Peelers' arguments made through Brown, Johnson, and Ross regarding the natural background and the significance of visual observations of vegetation stress on the Peeler Ranch. The Peelers have put these issues into play because their experts allege that their data and visual observations provide evidence of alleged property damage. Verslicka's opinions and expertise seek to speak directly to these allegations. Both in argument today and in their written pleadings related to the motion to exclude Dr. Verslicka, the Peelers have spent an inordinate amount of time arguing that the regulatory standards in ecological risk assessment are irrelevant. But that argument, even if it is correct, misses the point of Verslicka's testimony. Verslicka has education and decades of experience to assess both background levels and the reliability of conclusions regarding damage to vegetation as a component of alleged ecological harm. Your Honor, I'd like to touch upon 4 topics today. First, I'll begin by providing an introduction on the process of ecological risk assessment to explain why Dr. Verslicka's experience as an ecological risk assessor, in fact, gives him the knowledge, experience, and expertise to rebut the opinions the Peelers experts have given on natural background, the significance of vegetative stress, and gaps in their methodology between what they have done and conclusions of widespread contamination on the Peeler Ranch. Next, I will briefly review Dr. Verslicka's background and qualifications. I will do this very quickly because Ms. Whittle has helpfully already gone over much of his educational background. I will then explain the relevance of his opinions as a rebuttal witness in a bit more detail, and I do want to take a bit of time at the end to respond to some of the objections that the Peelers Council have raised with respect to the reliability of Dr. Verslicka's opinions. So, Your Honor, if I may, I will share my screen.
Go ahead.
So I'd like to begin by talking a little bit about the process of a screening level ecological risk assessment. Your Honor, a screening level ecological risk assessment is the first tool that we would use in trying to figure out if there is environmental harm from the presence of a substance in the environment. It could be salts, it could be metals. At other sites, it could be things like PCBs or oil. When you do this kind of assessment, it's intended to be an extraordinarily conservative assessment to ask the question, is there any potential of harm? And if there is a potential of harm, then you would carry through those contaminants to an additional, more detailed, fulsome ecological risk assessment. So the first thing you have to do when you're thinking about conducting a screening assessment is figure out what contaminants you're looking at and then define your screening value. As Ms. Whittle has pointed out, the screening value could be a regulatory threshold. And in this case, in fact, Mr. Johnson has used the Alberta Tier 1 standards as a threshold and a screening value for soil salinity, or it can be background. So what is background? Your Honor, this is an excerpt from Mr. Mark Hemingway's report, in which Hemingway explains that background is a term that is used to describe conditions in soil or groundwater that have not been affected by a release to the environment. So here in Mr. Hemingway's report, he's looking at the concept of a monitoring well that's up gradient of an impoundment and then a down gradient well. And so the basic concept here would be, since this well is above where the impoundment is in terms of the direction of water flow, then we would assume that whatever the concentration is we get here, and really in reality in a collection of water wells up here, tells us what the water looks like before it flows past this impoundment. And then if we see higher concentrations here, then we would infer that the impoundment is impacting the concentrations detected in the groundwater. So if you're going to use a background value, the first thing you do is you collect samples in unimpacted areas and calculate a background value based on that. This is what the peelers experts purport to do. They've selected a number of backgrounds, and we'll look at the locations of them in a minute, that are to the north and the west of the mine and the power plant, and they're using those to define their selected background value. There are a number of issues with that I'll go into in a bit more detail later on, but for the purposes of right now, let's just say you collect that data and then you choose your background value based on it. There are typically two ways that background values are calculated. The first is if the data set is very small, you might choose the maximum. The more common approach is to use a methodology that is prescribed by the EPA and also used by TCEQ, where you use a statistical approach to calculate the background value. And so when you do this, you take essentially the 95th percentile value. So there will still be a few values in your background set that are above what your background value is. So it would typically be 5 out of every 100 background samples would be above that level. And we do that to add a level of conservatism to the screening, because then if you have some outliers in your data for some reason, you're not having that influence the risk assessment. So once you have your screening value, your regulatory threshold or your background, the next step is to compare that to your environmental data. So this is what the peeler experts do. They compare their environmental data to the screening values that they have established, the calculated backgrounds for metals, and the regulatory threshold for salts. The next step in an ecological risk assessment is you look at whether you have exceedances or not, and I apologize, in a screening level assessment. If you see, sorry, I apologize, in the screening level assessment, the next step is to look at whether you have exceedances. If there are no exceedances, this is the end of the risk assessment process, and we would conclude that there is not a risk of harm. If there are exceedances in the screening level values, we would continue to a more fulsome risk assessment. And this is how we would determine if harm exists. What Dr. Verschleike is opining here is that the peeler experts have done this step. They've chosen a regulatory threshold for salt contamination. They've calculated background values for metal contamination. They've compared their data to these screening values, but then this is where they've stopped their analysis and they simply conclude that anything above that screening value is contaminated. Your Honor, are there any questions about that before I move on?
No.
So we've already gone over Dr. Verschleike's credentials in this case. He is a principal at Gradient. He has a PhD in applied biological sciences. Dr. Verschleike has conducted dozens of risk assessments outside of the litigation context. This includes both screening level assessments, like I just described to you, and more fulsome assessments. Because of Dr. Verschleike's experience in this area, he is more than capable of reviewing the methods used by the peelers experts and helping the jury to understand where there are gaps in those methodologies. We've heard quite a bit about what Dr. Vrshlyka's opinions are and what their breadth might be. I'd like to actually take a moment to look at those opinions with you. So this is page 2 of Dr. Vrshlyka's report, which has the summary of his opinions on it. We've already been over this first opinion. Fundamentally here, what Dr. Vrshlyka is saying is that the peeler experts have missed a step if what they're trying to do is say that there are widespread harms to vegetation on the peeler ranch. Again, Your Honor, this largely goes to the question of how one defines contamination in this case. And again, Dr. Vrshlyka is not opining on what constitutes contamination. He is simply pointing out gaps in the peeler's analysis. His second opinion is that soil background locations that were selected are not representative of the range of naturally occurring soil salinities within the peeler ranch and are skewed towards areas of lower salinity. That's meaningful because if the background concentrations are too low, then you are more likely to identify areas of the ranch as being contaminated with salt when they are not truly so contaminated. His third opinion is that the guideline values for evaluating soil salinity are not appropriate because they don't reflect this range of natural soil salinities at the peeler ranch. His fourth opinion goes to whether the background concentrations of metals really reflect a risk. The TCEQ values, the statewide median values, are levels that are used for these screening assessments that I have just described. So again, this does not go into the issue of whether the peelers have correctly identified the presence or absence of a metals concentration in the soil, but rather what the meaning of that is. Does it truly represent contamination in the form of damage to the property? And finally, Dr. Vrshlyka opines that because of these errors in calculating background and selection of screening values, that the peelers have delineated a much larger area of the property as suffering from ecological impacts than truly does. Your Honor, I'd like to direct your attention to figure 19 from Gordon Johnson's report. This pink outline here is the extent of contamination that has been delineated by the peeler experts. I believe this figure was actually drawn by Mr. Brown, but he has testified that he relied on some information from Mr. Johnson to do it. Functionally, what this pink outline shows is the area that the peeler experts have determined either has metals concentrations, and it's principally boron, that exceed background levels for boron, or areas that have salts that exceed the Alberta screening levels. So this is the area that is the area of alleged contamination. Dr. Vrshlyka's opinion is that relying on the type of screening assessment that I've just described to you, so comparing metals to screening to background values and salts to the Alberta values, is not sufficient to reach a conclusion that this entire area is contaminated. Now, as Ms. Whittle correctly pointed out, the peeler experts do also look at areas of vegetation damage to help bolster these opinions. However, when they do that, what they have done is they have chosen to rely on spatial coincidence of the visible vegetation damage to San Miguel's operations. As a matter of fact, there are reliable scientific techniques that you can employ in ecological risk assessment to try to account for multiple stressors and to think about whether they will cause impacts and which ones might be the cause of harm. And the peelers experts have chosen not to do those things. Your Honor, because Dr. Vrshlyka will help the jurors to understand that there are alternative established scientific techniques that the peeler experts could have used to establish whether the areas of vegetation impact are in fact caused by the by San Miguel's operations, and they chose not to do that. Dr. Ryszlejka's opinions are relevant to helping the jury understand whether the peeler expert's opinions are reliable. It's well established under Texas law that if an expert has failed to eliminate a causation that may be the sole cause of a harm, that their opinion is nothing more than mere speculation. I am not attempting to represent to you that there is another cause that is the sole cause of every incidence of an exceedance on the peeler ranch. That would be unreasonable. However, there are certainly some locations that have been discussed in detail in the reports of the experts where there are impacts from things like the peeler flowing well, which has high salinity, from localized oil and gas operations, and from grazing activities, where these activities have not been eliminated in a rigorous and scientific way as the cause of the harm that is being attributed to the peeler ranch. The other reason that Dr. Ryszlejka's opinions on harm to vegetation are relevant here is because the peelers have explicitly made them so. Mr. Johnson, in his opinion, relies on vegetation stress as one of the ways that he delineates harm. And when Mr. Johnson explains his selection of the electrical conductivity criterion of 2000 as what he's going to use as his screening value for salt contamination at the site, he says that one reason he's chosen that value is because it's a value that's consistent with the onset for sensitive field grasses, forages, and field crops that are common or introduced in the state of Texas. Mr. Johnson has therefore introduced concepts of ecological harm as one of the justifications for his selected threshold to identify potential contamination from salts. Mr. Johnson's report actually surveys visible surface vegetation stress, as Ms. Little pointed out, and he concludes that salt precipitation and vegetation mortality are prevalent throughout certain areas and attributes that to San Miguel, again, without the rigorous scientific analysis that could be done in ecological risk assessment. In choosing to rely on these lines of evidence, the peelers experts have made expertise in ecological risk assessment directly relevant to their case, and Dr. Ryszlejka can help the jury to evaluate those claims. Your Honor, I'd like to touch briefly on Dr. Ryszlejka's opinions regarding background. I'm going to share my screen with you again. So this is figure 1 from Dr. Ryszlejka's report. This is the analysis that Ms. Little mentioned earlier. This underlying map is the USDA surface soil salinity map, which was relied upon by Dr. Ross in some of her initial assessments. It was also relied upon by Mr. Johnson in his initial report. The black dots on this map are the locations where the peelers collected their background samples. The colors on this map show the ranges of salinity as mapped by the USDA. And the important thing to remember here is that the blue colors are lower salinities, and then the darker colors are higher salinities. We talked before about how background areas are areas that are up gradient of the impact we're trying to measure. And so what Dr. Ryszlejka did was he looked at the extent of the peeler ranch, which is the red line, and he looked at where the background samples were. And he drew this dotted line to be the rough extent of where the background area was. And that's how he makes his calculations about the percentage of each of these areas that is represented by a range of salinities. And then he looks at where the background samples are. And this is how Dr. Ryszlejka concludes that many of the soil salinities here are higher than what is used as a background value, and that many of these samples were in fact taken in areas that have lower soil salinities than the majority of this area, or I apologize, than 44% of this area. Ms. Little is absolutely correct that 44% is not 50% and it is not the majority. But what this does show is that there are a wide range of soil types that exist on the peeler ranch. Just for some background, Your Honor, the way that these USDA soil maps are made is that USDA soil scientists who are experts go out and they survey the properties and they look at the soils. And I'm aware there are no analytical samples that were taken on the peeler ranch. They were taken elsewhere in Atascosa County. But the way that these maps are created is experts in soil science go out and look at the soils, they determine what types they are, and then they rely on a larger data set to determine what, what the actual properties are. So what the expected salt level would be, what the expected levels of other minerals might be. And the really important point here is not necessarily what these absolute numbers are, but more importantly, the high level of variability across the ranch. And if you're going to use just one background value to cover the whole ranch, you're going to need to draw appropriate numbers of samples from each of the types of areas that are represented across the ranch in terms of soil type to get to a reliable background value. And that is the point that Dr. Verschleike is making. With respect to the screening values that Mr. Johnson has chosen, Dr. Verschleike takes a look at how those values compare to the peeler's own background samples. And so what you're looking at here, Your Honor, is this orange line is the Alberta Tier 1 guideline that Mr. Johnson has chosen, my apologies, for the soil screening value. These orange bars are the background soil samples. The blue line is the screening value for subsurface soil, and the bars again are the soil samples. So you can see that when you get into these shallow subsurface soils, many of the concentrations are well above this screening value. That suggests that this screening value is probably too low for the ranch. So, and as we heard earlier, Mr. McKinney's work supports the idea that this is a habitat that is full of salt-tolerant species. And here you see you've got a habitat that is perhaps saltier than the lower end of the onset of vegetative salt stress. That doesn't necessarily mean that this value is representative of the background state at the Peeler Ranch. I would note, Your Honor, that the Peelers Council also pointed out Dr. Verschleike's failure to consider the pre-mine soil salinity data. That data was not included in the initial reports of the Peeler experts to which Dr. Verschleike was responding, and he did limit his analysis to the data that was being used by their experts. And so as a result, he did not consider that. I'd like to touch just a little bit, if I can have just a few more minutes, Your Honor, on reliability.
Okay, I've got about 4 minutes. Go ahead.
Okay. So Dr. Verschleike is not offering opinions about the work of San Miguel's other experts. His purpose here is to examine the methodology that's been used by San Miguel's experts and to determine, by the Peeler experts, and determine whether those techniques allow them to draw the conclusions that they make. It is the Peelers and their experts who are alleging widespread contamination in this case. And Dr. Verschleike is offering one view of what contamination might mean and whether it has in fact been proven by the level of analysis that's been done. I do think it's also important to note that the Peelers Council have suggested that there has been no ecological risk assessment that has been done in the remediation work that San Miguel is doing to date. While it is true that ecological risk assessments have not been used to define the areas where remediation is happening, ecological risk criterion are in fact being used in determining how much soil to dig up. So generally, surface soils will be removed. If it's still too salty, then they will keep digging. And most of that digging will be limited to the top 2 feet of soil. And the reason for that is because when what you're worried about is the functioning of the ranch and its ability to support grasses that support cattle, once you get below the top 2 feet, plants' roots don't normally reach that far. In addition, San Miguel is addressing the CCR impoundments under the coal combustion residuals rule of the EPA, and Texas has recently adopted a framework of similar rules. Those rules explicitly incorporate the requirements of ecological risk assessment into their remedy processes. And so while ecological risk assessment has not been done on a site-wide basis to determine exactly what to remediate where and when, it is certainly part and parcel of the work that is going on the San Miguel property at this point in time. Your Honor, with that, I would just say that because Dr. Verschleike is being offered as a rebuttal witness, and he is responding directly to issues that have been raised by the Peelers' own experts, and he is qualified by knowledge and experience to offer these opinions, we ask that you deny the motion to exclude him.
Okay. We've got 1:20, so let's leave it there. If we need to have a bit more tomorrow before we get started on tomorrow's motions, we can do that tomorrow. If someone will send the coordinator a Dropbox link for tomorrow's hearings, I'd appreciate it. And
Your
else right
Your
now?
Honor,
Yes, ma'am.
I really just have 2 points if you want me to do it now or we can wait. Okay.
I've got to take off. This is a hard deadline where I've got to be somewhere and pick somebody up.
Yes.
Okay, so I will see everybody tomorrow.
Thank you, Your Honor.
All right.